Hello.
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 Good morning. I'm Matt McCoy. I represent Elite Concrete.
Yeah, my name is That's
nice. Thank you. Let's go.
Yeah, I want to make sure my volume's on. Can anybody hear me?
yeah.
Okay, great.
Yes.
Thank you.
All right, good morning, everyone.
Good morning.
Morning.
This is the civil motions and non-jury calendar. We've got a pretty full calendar here, and we've got, I believe, 42 people on the call. So I'm going to ask everyone, if you have not already done so, please mute your device so that we can minimize background noise and distractions while I deal with each of the cases. My intent here is first to go through to call the calendar, see which ones we can resolve quickly. If we don't have an appearance, or if we just need to continue it, get those done, then deal with the folks who are non-contested or just have a brief presentation of evidence, and then save for the back end of the hearing our contested cases that are going to need a little bit more time, just so that we can efficiently get folks in and out and minimize the number of people online. So I'm going to start calling the calendar in the order I have it, and let's see who we have appearing. Position 1 is Windward Community Service Association.
Mr. Bastien?
Hold on.
Yes.
We have Windward Community Service Association.
Yes, Your Honor. Mary Beth Sierra here for Windward.
All right.
Your Honor, Vlad Bastian, Your Honor, for the plaintiff.
Melissa Kylie with Windward Community.
All right, so as I look at the status here, I've recently set aside default. There's been an amended answer filed. So can the parties advise me of status? Has there been discovery?
Your Honor, my firm just recently took over this case for the plaintiff for Windward. And we filed an amended complaint, and the exhibits that we were planning to use in today's hearing, and we also provided those to your office. We have not done discovery. I believe there has been discussion of mediation. And in speaking with the defendant's attorney last week, that was mentioned again. We are happy today to the defendant's attorney and the defendant, if she's present, to try to work something out. Otherwise, we have not participated in discovery. I'm not aware of any that's been sent on either side.
All right, Mr. Bastian. So are
Yes.
y'all interested in either negotiation or mediation?
Yeah, I mean, we'll definitely listen, Your Honor, but we just got the amended complaint Thursday. Well, I actually got it in the mail today because when I came to the office. So it's a grave difference from the 6,000 that was alleged before to the 18,000 plus that's asked today. So we feel before I didn't have a need to have discovery much because the papers were given to me, but now it's almost like it's a different case if that would be it. So I'll talk to them as far as what they would accept, Your Honor. If maybe we could have a room, and then we could report back, Your Honor.
All right, I'm going to put y'all in a breakout room.
Thank you, Your Honor.
Thank you. And Melissa Kyler is our witness. She's on as well.
Yes.
All right, so I've created breakout rooms. Everybody that's on the Windward Community Miriam Dennis case, if y'all would choose breakout room 1. I think you just let me, I'm dealing with new technology here, so just let me know if you can't get in.
We will. We have 2 computers from our office. We will tell you.
All right.
One thing I have to tell you.
So you only need to join,
Which room, Your Honor?
you can join number 1.
Okay, Your Honor.
All right, so let's go to position 2, JH Portfolio Deputies versus Jervis Scott.
Good morning, Your Honor. Sharon Walker on behalf of the plaintiff.
All right, I do not hear from Ms. Jervis Scott. All right, so Ms. Walker, so this one's popped up because it's been sitting for a while. It's in default status. I do not see a motion on file.
And that's correct, Judge. We have been trying to get the affidavit from the plaintiff. And if Your Honor would just give us perhaps one more continuance to continue to press the client to get this affidavit so we can submit the default package.
All right. Give you one continuance there.
Thank you, Judge.
All right. Position 3, Sharina Williams versus WRC Consulting Services.
Good morning, Your Honor. Robert Cairns on behalf of the plaintiff. Your Honor, this case is on the calendar for damages hearing due to the defendant's default. Due to a scheduling error, we sort of already had this hearing a few months ago, but it ended up not going through. I've got about a 5-minute presentation. I don't imagine it'll take much longer than that.
All right. Do we have anyone here for defendant?
Yes, Your Honor. Mark Wyatt. Good morning, Your Honor. This is a contested matter. We have a default.
Hold on, sir. Can I get folks in the background? Please mute your phone. Getting a lot of background noise. All right, I'm sorry, Mr. Bartek. Try again.
Judge. I know how it goes these days. Anyway, this is a contested matter. We've got a motion to open default that has been filed or is being filed. And I think we've probably got 20 minutes, 30 minutes max from our side.
All right, so here's
Your Honor, briefly,
go ahead.
The plaintiff hasn't seen the motion to open default. I don't know if it's been filed or if perhaps it could be emailed to me. If there's going to be a potential open default, though, we probably shouldn't have a damages hearing today.
I think that's correct. So I think what we're going to do for you folks Since there's been a motion filed and the other side has not had a chance to respond to it, we'll reset this for a hearing on the motion to open default.
Thank you, Your Honor.
All right, so may we be excused, Your Honor?
You may be excused.
Okay. Yeah,
And Mr. Bardock, if you would email me that motion.
yeah, it's just, I just got the notification now that it's going through, so
Okay.
I'll make sure you get that emailed as well. And Judge, we'll look for a new hearing date from you.
All right.
All right.
Thank you, Your Honor.
All right. Position 4, A Better Way Rent-A-Car versus Woods.
Good morning, Your Honor. Deanna Smith here for the plaintiff.
All right. Do we have Mr. Woods? All right. So we had a motion for default as to liability in this case. That motion is granted. Are y'all prepared to prove damages today, or are you going to need another hearing for that?
Your Honor, I have my witness here with me. We are prepared to testify as to damages, and it shouldn't take 2 minutes.
All right. All right, we're going to come back to you.
Okay.
You'll be, when we come back around, you'll be the first, and we'll get you out of here.
Okay, thank you.
Position 5 was continued. Position 6, American Express versus Antonio Roll.
Judge, I'm here for that case. If the defendant is not here, I would just move to strike the defendant's answer.
I'm here. Antonio Roll's here.
I didn't see. There we go. Okay, bottom left, he's here. I'm here for the plaintiff, Your Honor.
All right, so Mr. Roll, my understanding from looking at the record is that you filed an answer. The answer is not legally sufficient to eliminate your liability. I understand y'all had some explanations in there for that. Let me ask you this, Mr. Green and Mr. Roll, do you want an opportunity to talk about it and see if you can work something out?
Sure,
Yeah.
Judge.
I would, yes.
All right, so I'm going to ask y'all to head into room 2.
Your Honor, could I wait? I have a couple other matters, but the next matter is the next position, and there's counsel on that one, as well as I have a witness. So if I could try and go to the breakout room for position 7 first, I think that would probably save some time.
All right, so Mr. Roll, I'm gonna have you sit tight for a moment. And so the next one you're here on is position 7.
Yes, Your Honor.
Unique Entertainment versus IMF Entertainment.
Here for plaintiff.
Who do we have for defendant?
Joshua Hideri for the defendant.
All right. So do y'all want to have some discussion about that?
Sure, Judge. That might help.
Sure.
All right. Are you hearing anything else, Mr. Green?
Yes, Judge. Position 8, which is the next case. I don't see Mr. Davis, so to be safe, I'd ask that that one be continued. That's Midland versus Maria Berrigan.
Maria Berrigan. Is Maria Berrigan or her counsel here? All right, there was an answer and a counterclaim filed.
Yes, again, I don't see Mr. Davis, and normally that we usually work these out with him. So I'd rather just be safe and continue this one.
All right. We'll give one continuance on that one. And what else do you have, Mr. Green?
Position 12 is mine.
All right, Midland Funding versus Courtney Frazier. Do we have Courtney Frazier here? No answer. That one, there was a motion filed and there was a proposed order. So that one, I'm going to sign the order now.
And then Judge, I just have one more, and that's position 25, Midland versus Michelle Morgan.
Right. 5. Michelle Morgan, do we have Michelle Morgan here? No answer. There was a motion for default. Order, that is granted. I will sign the order now.
Okay, Your Honor, just so my witness for position 7 knows to go to the breakout room, is it, his name is,
It's Castile.
Castile, I'm sorry, Courtier.
All right, y'all can join breakout room 2.
Thank you. Oh, I see.
All right, so getting back in order. Position 9, Windward Community Services Association versus Rotenberg.
Morning, Judge. Beth Taylor here on that particular Windward case. It is a default. We're here to prove our damages, and I have a witness on the line, I should say, Mr. David Hill.
All right. Come back to that one. Position 10, Medra, number 415 Family Limited Partnership versus Satam US LLC.
You did as good a job as I would have done, Judge. This is Will Downs here for Medra. This is a default also, Judge. I don't believe we've actually submitted a motion for default yet, but the only remaining defendant is the corporate defendant. We dropped the other 2 parties. So I do have a witness here. I'd asked your clerk if we could submit, default paperwork in advance, but because of the late notice, the defendant might have had an opportunity to show up. So we were asked to attend. I'm happy to, it should only take a few minutes, or since this is a lease case, I can submit default judgment after the fact.
However you want to do it, if you want to wait around, I'll give you a chance to present your damages. Otherwise, but in your testimony, but you're welcome to submit on the papers after the hearing today if you prefer.
Okay. I might just confer with my client and see what my client prefers to do, Judge.
All right. Just let me know. I'll swing back around to you.
Honor.
And actually, Judge, and just for ease of housekeeping, we'll just go ahead and set a motion. Your Honor has a pretty full calendar this morning. So I'm happy to submit a motion for default with a proposed judgment for liquidated damages.
All right. Then y'all can be excused.
Thank you.
We'll look for that motion. Give us,
All right, thank
give you 30 days. Let's give it.
Sorry, Judge, I'm
All
trying
right.
to get Mr. Hadari to join breakout room 2. I don't know.
Yeah, I don't see the option. I'm trying to Usually I get an invite to join the breakout room and I don't see the breakout.
All right, let me see if I can get you in there.
Thank you, Your Honor.
All right. Right. Next was position 11, Citibank versus Leben.
Good morning, Your Honor. Martin Marshall on behalf of Citibank. There is an answer filed in this case that doesn't dispute plaintiff's claims. But if defendant's present, I'd be glad to speak with her. Or otherwise, we're able to file a proposed order by the end of the day. But there's looks like an image on my screen that might be, I'm not sure if that's there because it's the defendant or if it's just a random image. But we have an affidavit and are prepared to file a proposed order if that be the case.
All right, we'll let you file an affidavit and a proposed order, and then we'll enter judgment.
Thank you, Your Honor.
All right. Position 13, Elite Concrete versus Richmond Hill Building Group.
Good morning, Your Honor. Matt McCoy for Elite Concrete LLC. This is a suit on an open account. The suit is in default. I have one witness present and prepared to prove damages. We did file 4 exhibits in advance of the hearing. I would anticipate 5 to 10 minutes of testimony.
All right, we'll swing back around to you. We'll let you prove your damages. Position 14, IBM Southeast Employees Credit Union versus Dumas.
Your Honor, Robert Kanjan on behalf of IBM Southeast Employees Credit Union.
All right, so.
Your Honor, we filed the request for default, filed the affidavits as well as attorney affidavit as well, and sent in both through the system as well as to Mr. Townsend a proposed judgment.
All right, I didn't see that at the end of last week. Was that something that happened just recently?
Yeah. Friday, we sent in the motion and then and the affidavits, and then this morning I sent in the attorney fee affidavit as well, and the proposed judgment was from last week.
All right, we'll take a look at those papers, and everything's in order. We will sign that judgment.
Thank you very much, Your Honor. Appreciate it.
All right. Position 14, position 15, State Farm Bank versus Johnny Jackson.
Martin Marshall on behalf of the plaintiff, Your Honor. In this matter, the case is in default, but we're still waiting on an affidavit from our client. It's the first time on the calendar, so we would ask for a continuance.
All right, Mr. Jackson is actually here in my courtroom, although you're unfortunately you're not able to see him today. So, Mr. Jackson, do you understand the status of your case? Do you understand that a lawsuit was filed against you and that you failed to answer? Okay, so you're saying that you did not get notice of a complaint?
You know what? I didn't even know.
Now you can stay right there where you are. It was a notice. If you can hand it to the deputy, put your mask back on, sir. see what he's referencing a piece of mail that he received. Is that our notice? Okay, so he received our notice of the hearing. Right. But he says this was the first notice he got of the lawsuit. I assume there's a.
It was Notorious Service, Your Honor, at the defendant's address of 4734 Brookwood View, College Park.
What's the address?
4734 Brookwood View.
4734 Brookwood View, is that your address? Okay. All right. So Mr. Marshall, defendant would like an opportunity to speak with you after the hearing today, see if y'all can work something out.
Certainly.
But what number can he reach you?
If
you want to type it in chat for me and I'll pass it on to him?
Sure, I can do that.
All right.
I'm not sure how to do that, Your Honor. Oh wait, sorry, here we go.
I've got it.
And just so Mr. Jackson knows, I have a couple more cases. Well, I have 3 more cases on the calendar. The last one is maybe, I guess, about cases ahead. So he might want to wait maybe 20 minutes or so before calling.
Yes. All right, Mr. Jackson, I've written down Mr. Marshall's name and phone number on this paper, so you'll call him and you'll have a chance to have a discussion. If you can work it out, there'll be paperwork for you to sign and you don't have to come back here. If you're unable to work it out, then there'll be then there'll be another hearing scheduled later. So you're free to go today. That's correct. Mr. Martin Marshall, that's correct. That's the attorney for the State Farm, yes. He won't be available right this moment. So because he's got other cases on the hearing calendar today, you can call him tomorrow. I will let him know. All right. Mr. Jackson's going to call you tomorrow, Mr. Marsh.
All right.
All right. So you're free to go, sir. I appreciate you finding a way to get it. All right.
Your Honor, I have I guess, a quick announcement or just to kind of see what you'd like to do with position 7.
Yes.
We're unable to resolve it. In speaking with counsel, he said his side was going to take about an hour. Our side is probably going to take about an hour as well. In addition, I have a couple of videos. Right now, I have one witness. I'm not sure how many his client has as far as witnesses. And I have a conflict this afternoon at 1 o'clock. I didn't realize how large this calendar was going to be. I'm wondering if the court would be willing to specially set this matter in the next couple of weeks whenever you might have a free morning or afternoon, or if you want to hear the case. And again, we would be ready today, but I'm a little concerned about running into this afternoon.
All right, Mr. Haidari, do you have any issue with specially setting this for an intensive hearing?
I don't, Your Honor. If we are going to reset this, then I would ask for a little bit of time because I do plan on making a dispositive motion, which might eliminate a need for trial altogether.
Well, the only thing I would say, Judge, is that at the last hearing, my understanding, and this is back in March of 2020, Mr. Haidari continued the case because he said that he had filed discovery responses. We ended up getting those discovery responses a week ago. So I would argue that the time to file a dispositive motion is passed. If he wants to argue it in the pretrial to the hearing, then that's fine. And I believe we'd be able to adequately respond as I'm going to have my client. But as far as just continuing this to file dispositive motions, that time has clearly run its course.
I would agree with that. I think you can make the same substantive arguments you would make on summary judgment at the hearing. I'm going to ask, we'll reset it and specially set it. I'm going to ask that y'all exchange all exhibits that you plan to use at the hearing and copy the court on that so that we.
Yeah, yes, Judge, because there's a video that we're going to need to submit to you.
So that we're all operating from the same playbook when we get back here. All right?
All right, thank you, Judge.
All right, that'll be further notice on that.
Thank you, Your Honor. I'm going to join a breakout room with Mr. Roll. Do you want me to go back to breakout room number 2?
Is that where you were in room 2?
Yes, sir.
All right, and Mr. Roll, I'm going to assign you to room 2.
May I be excused, Judge?
You may be excused.
Thank you, Your Honor.
Thank you. All right. We are at number,
I believe it's 16. Your Honor.
16,
Yes.
State Farm versus Daisy Arnold.
And I'm here on that one as well, Your Honor. Again, the case is in default. I'm not sure if the defendant is present. But it's the first time on the calendar, and we would like a continuance in order to obtain an affidavit from our client.
All right, we'll let you get your paperwork in order so that we can enter default on that one.
Thank you, Your Honor.
Then we have 17 Plaza Services versus Liza Richards.
Sharice Taddy for the plaintiff, Your Honor.
I'm here. This is Lisa Richards.
Right. So I have this as defendant not having filed an answer, so the case is in default status. I do not believe there's been any motion filed. Do y'all want an opportunity to talk and see if you can work it out?
Sure, Your Honor.
I don't even know what this is about exactly, so I would love the opportunity to talk.
All right, so do you, let's see. Ms. Taddy, do you have any other matters on the calendar?
I do not, Your Honor. This is my only matter this morning.
All right, so I'm going to ask y'all to join room 3.
Thank you, Your Honor.
All right, position 18. De La Cruz Stone Masonry versus Carlson Mill LLC. Have anyone here on that one? All right, position 19, Ally Financial versus Shakimia Ragland.
Good morning, Your Honor. Jeremy McCullough on behalf of the plaintiff.
Right, that one is in default status. I do not show any motion on file.
That's correct, Your Honor. We tried to get one filed before the hearing, but we're unable to do so. So we would just request the opportunity to go ahead and file a proposed order in motion for default judgment for the court's consideration.
All right, we'll let you do that.
Thank you, Your Honor. And that's all I have. If I can be excused.
You may be excused. Thank you.
Thank you.
Position 20, Law Offices of Frank Lightmas versus John Paris. That's settled. All right. Number 21, Bank of America versus Elvin Coulter.
Good morning, Your Honor. Attorney Alex Capers here on behalf of Bank of America.
All right, so there was a motion here, I believe, to quash service and to issue out a new summons.
Yes, Your Honor.
All right, so I'm going to grant that motion, and I'm going to, yes, I'm going to grant that motion and sign the order right now.
Thank you, Your Honor. That's my only matter. May I be excused?
You may be excused.
Have a great day.
Thank you. All right, next we have Opportunity Financial versus Monique Russell. That was a dismissal. Number 23, Coca-Cola Refreshments versus Jeffrey Medjbo. That was also a dismissal. Number 24, Metro Trailer Leasing versus All City Express and Ibrahim Komalov.
Yes, Your Honor. Allison Crane for Metro Trailer Leasing. My office did send out notice as per the court's instructions of this hearing to both Ibrahim Komalov and All City Express. We sent those notices to the last 3 available addresses for each defendant, and we have not received a response. We did this morning file a motion for default that was accepted by the court. I do have a representative for Metro here. We did previously submit all of our evidence regarding damages, and we're prepared to proceed as Your Honor sees fit.
All right. So you have so in the papers that you filed, is there an affidavit from your witness or a witness for the company?
Well, I have the witness available, and all of the records are certified. We did file a certification and a verification on the initial pleadings.
All right, I will hear your witness's testimony. We'll come back around to you.
Okay, thank you.
Bear with me and we'll get your damages hearing. All right, position 25, Midland Funding versus, oh, I already did that one. 26, Jefferson Capital Systems versus Asia Thomas.
Martin Marshall on behalf of plaintiff. Again, Your Honor, this is another case that's in default. However, with this case, there's a pending dispute which our client is investigating. The dispute's kind of old, so it may have been resolved. We aren't sure at this point. So we would ask for a continuance in order to determine what happened with that dispute.
All right, we'll grant your continuance on that one.
Thank you, Your Honor.
27, Galaxy International Purchasing versus Jessica Ballesteros.
And I'm here for the plaintiff on that one as well, Your Honor. We did file a request for default judgment with a proposed order and affidavit last week.
All right, so I think you probably need to redo the affidavit, because the affidavit does not authenticate the business records that are showing the amount due or the proper holder of the debt. I think that's included, it's attached to the complaint, but the complaint is not verified and the affidavit doesn't reference it.
Okay.
So I just think you need a little technical adjustment, and then that will be ready. So if you can make that adjustment and send me an order, we'll get that in.
All right, thank you, Your Honor. And that concludes my business with the court. May I be excused?
You may be excused.
Thank you. Have a great day.
Do. And 28, Discover Bank versus Eric Quarles.
Good morning, Your Honor. Ian Busey on behalf of Discover.
Not hearing from defendant. So this one, I believe, is in default status.
Your Honor, we have had communication with the defendant. We reached a settlement agreement with him, and he notified us that he overnighted the paperwork back to us last Wednesday. We still haven't received it, however, but to be on the safe side, we ask for continuance to fully investigate that.
All right, well, we'll grant you continuance, and hopefully there'll be either a dismissal or a consent judgment on that one.
Absolutely, Your Honor.
All right.
That concludes our business. May I be excused?
You may be excused. Thank you, sir.
Thank you, Your Honor.
29.
Judge, I had a quick announcement. Sorry.
Yes.
I was able to settle position 6. With Mr. Roll.
All right. Mr. Roll here?
You should be.
I'm here.
All right. Mr.
Judge,
Roll, you have a camera, Mr. Roll, that I can see you?
Yes, just a moment. Hey, good day.
All right, thank you. Thank you, sir. So,
Yeah.
Mr. Roll, Mr. Green, would you just give me the general outline of the resolution?
Yes, Judge, he's going to pay a settlement amount of $14,150.73 over 18 months. Those are payments of $786.15 due March 1st and every 1st. If he does default, it'll divert to the full balance being owed minus any payments that were made. And I'm going to email him a copy of a consent tonight, and hopefully we can get the paperwork over to Mr. Townsend.
All right, Mr. Roll, you agreed to those general terms of the settlement?
An agreement, yes.
All right, so you understand that if you don't, I'm going to sign an order that memorializes your agreement, and if you don't abide by the terms of the agreement, they may come back and get a judgment against you for more than what your agreement is.
Understood, and I concur.
All right, very good. So, Mr. Roll, you are free to go, and Mr. Green, and you, I will.
That would conclude all my business, Judge, if I could be excused.
Thank you. Have a good day.
Mr. Green, you can be excused as well. Thank you.
Thank you.
Back to Richardson versus Fife.
Good morning, Your Honor. Pat Dixon on behalf of Mr. Fife.
Good morning. As well, it's here.
Do we have Mr. Richardson?
Yes, good morning, Your. Good morning, Your Honor.
Morning.
Hi.
All right, so I have a motion to compel and a motion for summary judgment. Now, the motion for summary judgment, I think, was just
Yes, Your Honor.
filed.
Yes, Your Honor, it was filed yesterday. The motion to compel was filed on February 11th. Because we did not get discovery judge, we're not ready to move forward today, but we believe that our motion for summary judgment is dispositive of this case in full.
All right, Mr. Richardson, so the motion to compel was filed about 10 days ago. Now, typically I would try and give some folks the normal time to respond, but I'd be very interested in hearing
just a little background,
what your position is.
And just a little background, Your Honor. We sent formal discovery 5.2 to Mr. Ricky Richardson, who was also on the call, who represents the plaintiff in this matter, on December 20th, shortly after our last appearance in front of you, Judge. We got no response. Quite honestly, Judge, I haven't gotten a response from Ricky Richardson at all. I have not one email from him, period. On January 26th, per the Uniform Superior Court rules, we sent a 6.4 letter, telling him that he had 10 days to resolve the discovery dispute. He did not respond, no email or anything. After that, after the 10 days ran, that's when we filed our motion to compel. And so he's had plenty of time to answer this discovery. It's a reason why he's running from this judge because, and I also asked him for deposition dates between January 18th and February 18th. No response on that. We believe that the discovery responses that he provides us or deposition will give us what we need for a dispositive motion, which is why we went ahead and filed it because he has admitted everything we need for motion for summary judgment in this case.
Mr. Richardson, let me hear from you. You're on mute.
Yes, Your Honor.
You're Mr. Fife?
No, Your Honor. That's Mr. Richardson, the plaintiff. Mr. Ricky Richardson.
I want to hear from Mr. Ricky Richardson,
yes.
The attorney. I've got my Richardsons confused.
And I believe he's on mute, Judge.
Attorney Richardson, you're on mute.
I apologize, Judge. This action was initially filed by the plaintiff for possession of the property and backment of payment of rent. The action initiated in magistrate court, wherein the defendant in this case has been a tenant in sufferance for about 1.5 years without paying any rent. In November or December, the court ordered that the defendant pay into the court registry $1,000 per month. At that time, counsel for the defendant attempted to have the case transferred to Superior Court where they have a parallel action. Now, I'm not the attorney of record, but I did pull the motion, and they filed on December 7th a petition of Keontae Fife for injunctive relief, declaratory judgment, promissory estoppel, specific performance of contract, breach of contract, and damages. They attempted to get this court to transfer this action to there. The court refused to allow that and said, we'll address the issue of ownership or possession of this property, and then he can deal with that at a different time. I ended up not being well, went out on medical leave, and apparently Mr. Dixon bombarded my email with various things. I did attempt to call him. He's been combative and belligerent with me, Judge, profanity, etc. Judge, we were here today to address the fact that Mr. Keontae Fife, who is not an owner of this property, is a tenant, has been there for 18, 19 months and not paid rent and refused to leave also, and is not his primary residence. So the motion to compel, I don't see that is germane in this court. There is another action. Like I said, Judge, they're aware of that they filed another action in Superior Court under case number 2020 CV 343222, when I look at that and I go back in my emails, it's the exact same action, almost the exact same documents, if not exactly the same documents they filed there in Superior Court as they filed here in this court. Judge, we filed the motion to regain possession of the property and back rent if they think they have a contractual issue in terms of compelling Mr. Richardson to sell his property. Then that is the Superior Court is a proper forum for them to try and backdoor and file a summary judgment last night. That's kind of been it. In fact, Mr. Dixon filed a leave of absence with Mr. Townsend on Friday, saying, can we continue this action? It's always been an attempt to avoid turning the property back over to the rightful owner and paying rent. So there is a forum for it. This just isn't the forum. The forum is the Superior Court. And in judicial economy, that's where it should be under 20.
Well, Judge, I think he sort of cut out what.
To get the court to transfer that case to here and to dismiss this case, or whatever his request was. The court summarily denied it and said, I think we need to have a hearing on the issue of ownership, on the issue of the eviction, and then we'll address the other stuff. That was the court's information to Mr. Dixon.
So, Your Honor, just a response to Mr. Richardson, I deny that I used profanity against him, stand in my place as an officer of the court. Second of all, Judge, Mr. Richardson argued against the motion to transfer. We thought that the appropriate motion forum was Superior Court. He argued against that, which is why we are still in before you, Judge. And so because of that, we filed discovery requests shortly after your denial of that. And, this case falls under the Georgia Civil Practice Act. We're owed discovery. And Mr. Richardson did not give us one legal or legitimate excuse why he did not respond to the discovery. He claims he called me. I received not one call. He did not email me not once. And so we do believe that the appropriate forum for this entire case, for all the matters, is Superior Court, but you are denied that, Judge. And so, and just a little bit about the leave of absence, you can check with Mr. Townsend. I filed the leave of absence approximately 2 hours after the calendar was published on January 26th. What Mr. Richardson is referring to is that I had emailed Mr. Townsend the status of the leave of absence to see if we were excused from today's calendar. Mr. Townsend said we were not, which is why myself and my law partner, Mr. Dixon Jr., is on the line here. So it really has nothing to do with today. We're not trying to prolong this, and in fact, we would be ready to go today had he responded to my discovery on time, would have agreed to the deposition. It is a reason why they do not want to respond to formal discovery. Is a reason why they do not want to sit Mr. Richardson down with me for a deposition. And so, there's appropriate form and appropriate document should have been filed, would have been a protective order. Or if he was on medical leave, Judge, he could have filed a medical leave. He did not do any of that. And so we're asking for you to reset so you could look at the motion. They have no legitimate excuse to withdraw the admissions. And so we think that our motion before you today is fully dispositive of this case. And like Mr. Richardson just said, we have a pending action in Superior Court, which we're seeking injunctive relief and specific performance. And so he still has a remedy, at hand that he will be able to go in front of a Superior Court judge. So we're asking you today to either dismiss or grant our motion for summary judgment.
All right, so Mr. Dixon, I think you're entitled to discovery under the Civil Practice Act. I haven't seen the actual discovery, so I can't speak to the breadth and scope of discovery, whether it's issues related to this lawsuit. Background noise. All right. So the time has not come yet for a response to the motion to compel. I believe that's going to come within the next 3 weeks, 20 days or so. So, Attorney Richardson, so has there been a response to the motion?
There has not yet, Judge. I really just became aware of it. I can certainly have all of his responses or response to the motion to compel before the close of business on Friday. It's not very much to it. He already has the documentation, but I'll send him. It really is our exhibits today. That is the sum total of it. It's not really a whole lot to the case. It was a rent agreement, and he didn't pay the rent. It's not really complicated.
All right, so what we're going to do is we're going to give Attorney Richardson and Mr. Ricky Richardson an opportunity to respond to the motion, provide any documents or any information that they feel is responsive if they choose to do so within that time. And then if I'll reset for a hearing if there are any other issues. If there are not any other issues and it's resolved, we won't need to go through that hearing, but we can prepare, sounds like we can prepare for a trial on the issue of possession and rent.
Yes, sir. And Judge,
does that sound correct to you, Mr. Dixon?
I'm fine with whatever the court wants to do, Your Honor. We also believe that, he can respond to the motion to compel, but we believe that our motion for summary judgment is going to be dispositive of this case.
All right, so let's make sure that everybody has the information that they need from either side, and then we can deal with the motion for summary judgment based on all the evidence in the record.
Yes, Your Honor.
All right.
I'll take care of that today, Your Honor.
Thank you, Judge. Might be excused.
Thank you both. You may be excused.
All right. Thank you.
Your Honor, I have a quick announcement.
Yes, and Ms. Patty?
Yes, Your Honor, on Plaza Services versus Eliza Richards. Ms. Richards, are you back with us again?
I am.
Excellent. So I've had the opportunity to speak with Ms. Richards. I believe that we are going to settle this matter, Your Honor. The defendant does want an opportunity to be able to review the information I gave her, and I'm going to also re-provide her with all the documents on this file. I anticipate it's going to resolve itself in the form of a consent judgment and will be removed before the next hearing. And it's based on that, Your Honor, that we're going to jointly ask for a brief continuance. I'd love 30 days, but I'd take 60 if you'd give it.
Let's try 30. Ms. Richards, you're okay with a settlement here today?
Yes, I am.
All right, so that settlement requires you to make monthly payments, is that correct?
Yeah, well, essentially, yes, absolutely. I just want to, Ms. Ted A is going to send me all of the documents for me to review, and then I'll come up with something and we'll discuss it before the hearing.
All right, so y'all haven't set a number yet.
Right. She knows everything but the exact amount that she's going to pay. She knows the balance that she owes on. She knows that it's going to be on a monthly basis. We've exchanged information. So we're 90% there, Your Honor. She just wants the opportunity to be able to look at her bills and see what amount that payment is. And quite frankly, Your Honor, we have quite a bit of flexibility on that for plaintiffs. I don't see that that's, whatever amount she comes in with should be good.
All right, sounds like you're going to be able to resolve this. If you do resolve it, obviously, Ms. Richards, there's going to be paperwork that's going to be filed with the court, a consent judgment. And, you have no obligation to agree to anything, but if you agree to it and sign it, it's going to be an order of the court. And then if you don't follow it, there could be adverse consequences, including being responsible for the full amount immediately.
Yes, Your Honor.
All right, very good. Well, then I will.
Oh, Your Honor, if I may, I forgot to point out, the court noticed that said that there was no answer filed. The court docket reflects that the defendant did file an answer in January. So just procedurally wise, I don't believe this should be set for a default next hearing. I think it should be set for a trial with candor to the court.
I must have missed that, but I'll make sure that I have that noted.
And that's my only matter, if I may be excused, Your Honor. Thank you.
Yes, you may be excused, and Ms. Richards, you're free to go as well. Thank you.
Thank you.
Now we are on position 31, and that was dismissed. Position 32, Cavalry SPV versus Kelly Hull.
Good morning again, Your Honor. Sharon Walker on behalf of the plaintiff. And Judge, on this case, I didn't hear the defendant answer, but she did contact us last week in an effort to try to resolve this issue. We did Well, we have a settlement for her, and but when we try to call her back, we did not receive an answer. So if we could just get a continuance, Your Honor, so that we could perhaps get the signed document to her and back from her, so we can submit that with the court.
All right. We'll continue that one.
Thank you, Judge.
$33, Cavalry SBV versus Aaron Sims.
Sharon Walker on behalf of Cavalry again. And on that one also, Your Honor, similarly, the same situation. However, we did make contact with Mr. Sims. We did send him the consent order, but we have not received the signed copy back from him. And that was last week when we did all of that.
Right.
Another continuance, Judge.
All right, we'll continue that one.
Thank you, Your Honor. That's all I have for today, Judge. May I be excused?
You may be excused.
Thank you, Judge. Have a good day.
Right. I have position 34, Heatherwood Condominium Association versus Morris Taylor.
Good morning, Your Honor. This is Spencer Farmery on behalf of the plaintiff. We also have Elijah West, who's the plaintiff's witness if needed, and Mr. Michael Brown, who is counsel representing or handling the defense of Mr. Taylor's counterclaims.
Good morning, Your Honor.
Good morning, Your Honor.
All right, so are y'all ready to have a hearing on this today?
If needed, Your Honor, the parties did attend a mediation as ordered by the court back in August. We were able to come to an agreement at that mediation. Insurance did send proceeds to Mr. Taylor in compliance with that agreement. Mr. Taylor, I believe, attempted to comply with the agreement by sending the check that he received from insurance directly to us. I tried to get in touch with him. You know, he was supposed to technically cash that check and then send a second payment to the association. But we weren't able to successfully agreement to get that. Paragraph 5 of the agreement says, in the event homeowner receives the funds and does not remit them to the association, an order shall be entered against him in the amount of $5,249.43. Association would ask that that be enforced. But I also understand that insurance is willing to comply with this agreement, and meaning they'd send another check to Mr. Taylor and start the process over if Mr. Taylor's willing to.
Your Honor, this is Morris Taylor. I rescinded my mediation agreement because it was an unconscionable contract. We wouldn't even be here if they would have did all the things they are now.
Mr. Taylor, I can't see you. Mr. Taylor, I can't see you, and I'm having difficulty hearing you.
Well, can you hear me now?
I can hear you a little bit better. Do you have a camera?
Yeah, it's not on.
No.
Is it on now? Is it on now, sir?
No,
Your
it's
Honor?
not. It is not. There we go. Now I've got you.
Okay. Your Honor, I rescinded that agreement because it was an unconscionable contract. You know, if they would have did everything that they are doing now in the beginning, we wouldn't even be here. You know, they finally cut the tree down, but they didn't address my issues. They taking my issues and paying for them, but in the form of payment, they want me to get the money back to them, so it's not fixing my problem. And what I'm thinking is, I don't feel like I should have to pay the attorney fee, because you wouldn't need an attorney if you would have been doing the things that you're doing now to have caused the problem. So they agreed to that I will by and this problem, turn around and pay the attorney fee when you didn't need an attorney fee if you would have just did the thing that you're doing now. And so that's why I didn't want to cash that check, because I because you gonna use the insurance company that going to me to pay out my claim, but you want me to give it back to y'all as fees. So my property is still not getting repaired. And they sent some lady around to look at the roofing just to patch it up, which they done patched up more than one time in the past, and I still got leakage problems through the top of my roof. I mean, in the top of my bedroom and attic door. And I just didn't think that was a fair deal for them to use a claim on my condo to pay their fees. Because I'm still stuck with damages if I was to go through with that agreement, Your Honor. And you said in the name of justice, you allow my counterclaim in, but they didn't even worry about negotiating. They just went straight to paying their fees and not addressing none of my concerns.
And Your Honor.
And now they won't pick up my telephone. I tried talking to the new association. She won't answer my phone. And that guy there, he approached me in a hostile manner, told me don't ask him for nothing. So I'm out. The homeowner association won't speak to me. The president of the association won't speak to me. And so what am I to do, Your Honor? And then they ran a background. They did a credit check and put a hard inquiry on my credit report. So they see that I pay all my bills on time. I got a 100% pay record for paying all my bills on time. And once again, we wouldn't even be here had they did the right thing in the beginning.
All right, Mr. Taylor, let me hear from Mr. Brown.
Thank you, Your Honor. Good morning. I was retained, I believe, on Friday to defend this counterclaim. I was going to support the enforcement of the mediation agreement. But if that was not going to go through, I was going to ask this court to dismiss the counterclaim as being untimely, as it appeared to be a compulsory counterclaim. But if you've already ruled on that, I was unaware of that, and I will not ask the court to reverse its own ruling. So I'm playing catch up a little bit, Your Honor, so I apologize.
All right. So it sounds like, so Mr. Taylor, if you don't want to go through with the deal in mediation, that means I have to have a full trial on their damages and on your counterclaim. You understand that? And that you could wind up better off or worse off than what you had initially negotiated.
Your Honor, I don't think I have a problem paying fees. You don't feel like I should pay large fee, because I don't.
I'm having some trouble. I'm having some trouble with your
just
connection.
Your Honor, I don't know what to do. I totally have computer savvy when it comes to this Zoom thing, and I'm trying to relate my information to you best as I can, Your Honor. Can you hear me?
You're going in and out, so it's very difficult to get a clear picture of all the things that you're saying. Counsel for the Condominium Association. So are y'all prepared to have a hearing, a full hearing on this, or you think you need more time?
We're prepared today if we need to go forward, Your Honor.
All right,
to proceed today if we can't resolve this with a dismissal or an enforcement of the mediation agreement. Yes, sir.
Mr. Taylor, are you prepared to prove your case?
Yes, Your Honor, I guess. I don't know. I'd rather do it in person since you have a problem hearing me. I tried to send some pictures in. I don't know if they got there. I don't know, Your Honor. I don't have the funds to get an attorney. I tried talking with Atlanta Legal Aid and they wouldn't help me out, so I don't know what to do, Your Honor. I just think that deal that we made was unfair because I'm still not getting my condo repaired, Your Honor. You told me to make sure I had that fee that I owed them, and I'm trying to do everything the right way. I don't think I want to do it, get my repairment done, because this has been mental anguish on me for a long time, Your Honor. And at one time, I feared for my life before they cut the tree down, and and it just getting worse and worse from that point on.
I think this is going to be complex, and I think this is going to take a good bit of time. I think I'm going to continue it. We're going to specially set this for a full hearing on the claim and the counterclaim.
Okay, Your Honor, that works. That works for us too, I believe.
And Your Honor, since I was just retained, would the court permit me to send some brief discovery to Mr. Taylor regarding his counterclaim?
It needs to be brief.
It very much will be, sir. Thank you.
All right. We're going to put it out 60 days. And we're going to try to have a hearing in person. I hope that we'll be in position to do that, so that we can be in person. But if not, we'll do it if we can't be in person, we'll do it by Zoom.
Yes, Your Honor.
Yes, sir. Thank you.
So, no further business. Y'all may be excused.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
I think I have gone through the first pass. So let me come back to folks that have witnesses and damages that they need to present. Let's go back to position 4, A Better Way Rent-A-Car versus Woods.
Hi, Your Honor. Deanna Smith here. We are ready to proceed if you are.
I'm ready.
Excuse me, Judge Richardson, is this a case that needs to be taken down?
No, we don't need this taken down. Thank you.
Thank you, Judge. Is that all my business for today?
Does anyone else who's still on the line believe they need the services of a court reporter?
No, Your Honor, not on behalf of Elite Concrete.
Right. Then, Ms. Winfrey, you may be excused.
Thank you, Judge. Have a good day.
Okay. Hi, Heather. Can you please raise your right hand for me? Do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Please state your name.
Heather Ivins.
Where do you work and what is your title?
Better Way Leasing, claims manager.
For how long have you been employed in this capacity?
15 years.
Okay. Do you have training and experience in evaluating property damages to vehicles?
Yes.
Are you familiar with the loss that occurred on May 25th, 2018?
Yes.
And are you familiar with the contract between George Woods and Better Way Rent-A-Car Inc. doing business as Budget of Atlanta?
Yes.
Okay. Your Honor, at this time, I tender this witness as an expert.
All right.
Okay.
He is accepted.
What type of vehicle was insured?
2018 Jeep Grand Cherokee.
Okay. In your opinion, what was the fair market value of this vehicle immediately before the collision?
$34,538.
Okay. And were there damages to this vehicle as a result of the collision?
Yes.
In what amount?
$2,751.51.
Okay. And did budget incur any loss of use?
Yes,
In what amount?
$309.95.
And was any diminished value assessed for this vehicle?
Yes,
In what amount?
$968.
Okay. And what is the total amount of the damage claim?
$4,029.46.
And is that amount fair and reasonable in light of your experience and the damages resulting from this collision?
Yes.
Okay, thank you. Your Honor, at this time, I submit to the court that we're asking for $1,000 in attorney's fees. I submit to the court, I spent 4 hours on this case. That's reviewing, filing, and my time here today. And $250 an hour is reasonable and customary, which equals $1,000.
All right. I'll grant judgment in the amount requested.
I do have a proposed judgment for you if you'd like me to email that to someone.
Yes, you can email that to Mr. Townsend. And we will go ahead and get that judgment entered.
Thank you, Your Honor. I believe that's all we have. May we please be excused?
You may be excused.
Thank you.
All right, let's swing back around to position 1, Windward Community Service Association versus Dennis. I see Mr. Bastian.
Yes, Your Honor.
On,
Mary
and I
Betsy
see
right
Ms.
here.
Yeah, Your Honor, it doesn't look like we could resolve this, but I don't think it should take a long time.
So it sounds like we're not ready for trial since we just had the amended complaint, and you say you haven't had an opportunity to respond.
Well, if it's an amended complaint, I think I know where they're going, Your Honor. If the complaint is deemed denied as it is, I'm ready to go because there's only 2 issues.
Well, I think they've filed it in advance of trial. So I'm prepared to allow the amendment, but give you whatever extra time you need to respond to it, or if you need discovery on it, that's fine as well.
Okay, Your Honor.
But that's up to you. If you want to proceed based on the amended complaint and we're all ready, then let's go. But if you're saying you can't be ready because of this recent amendment, then I'm going to give you that space.
No, I'm ready. I mean, I guess, but pursuant to the amendment, I just want to make sure we all in the same line that it's deemed denied. I don't have to formally put a response to it.
You don't have to formally put a response. No, it's deemed denied. Yes.
Thank you. Yeah, so I'm fine, Your Honor.
All right. So we'll come back around and we'll have a hearing on that.
Thank you.
All right. So let me get the non-contested ones out of the way. So position, I think the next one is position 9, Windward Community Services Association versus Rotenberg.
Beth Taylor here for that one, Judge, and we're ready when you are.
All right, go ahead.
Okay, I do have a witness. Mr. David Hill, can you unmute yourself and raise your right hand? Do you swear and solemnly affirm the testimony you give the court today is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And can you please share with the court your role with the plaintiff in this case, Windward Community Services Association?
I'm one of the managers assigned to Windward Community Services.
Okay. And as a manager for the association, are you familiar with the books and records of the association?
I am.
Okay. And does that include the declaration, the bylaws, and the rules and regulations for the association?
Yes, that's correct.
Okay. And pursuant to Article 4 of the Declaration, is every property and owner of property within the community required to maintain their property in compliance with the standards set forth in those governing documents?
Yes, they are.
Okay. And pursuant to the declaration, if an owner fails to maintain the property in compliance with the declaration, the bylaws, and the rules or regulations, is the association entitled to levy fines for such covenant violations?
Yes, it is.
Okay. And Also pursuant to the declaration is every homeowner within the community required to pay annual assessments to the association.
They are, that is correct.
Okay. And pursuant to the declaration, are the annual assessments as well as fines to be collected as authorized to include late fees for assessments, interest accruing on those amounts owed, and cost of collection?
That is correct.
Okay. Can you share with the court just, are there fines at issue in this case today?
Yes, there are fines related to several different deferred maintenance issues, such as not painting of the black metal fence, allowing the seawall to collapse into the lake, which is causing erosion issues, not cleaning, repairing the driveway area, things like that.
Okay, and can you just generally, prior to fines being noticed, what is the process that the association follows to try to get a homeowner in compliance before resorting to levying fines as a tool for compliance?
We issue at least 3 notices in each of those instances that I mentioned a moment ago, typically within 20 to 30 day time period, at least between each of those notifications written that are issued to the property.
And after that third notice is sent and a homeowner continues to fail to bring their property into compliance, are fines then levied?
That is correct.
Okay. And Your Honor, I did share with Mr. Townsend copies of the violation letters that were sent, as well as copies of the declaration, bylaws, and the rules and regulations prior to the hearing. I would normally be tendering it at this time, and it was tendered via email.
I did receive those, and those are admitted.
Thank you, Judge. So, Mr. Hill, can you share with the court today how much in unpaid assessments does the defendant in this case owe to the association?
Are you talking just the annual assessments or all the assessments, including the fine amount?
Let's do the annual assessments, just the annual assessments.
That'll be $3,550.00.
And those are just for the regular annual assessments. Now,
That's
with respect
correct.
to the fines, this case is unusual because there are a large amount of fines, correct?
That is correct.
But is that a result of a large and long-standing amount of violations in this situation?
Unfortunately, yes, that is what's made this occur.
Okay. And did the association actually stop levying fines in October of 2020 just to kind of put a cap on things?
That is correct. Yes.
Okay. So can you share with the court today how much in fines have been levied with respect to these covenant violations that have been going on for years?
$79,095.00.
Okay. And in addition to these assessments and fines, can you share with the court how much interest has accrued on these amounts owed?
$8,359.42.
And is that interest accumulating at the rate of 7% per annum?
That is correct.
Okay. And in addition to these principal amount and the interest, is the association pursuant to the declaration entitled to recoup its cost of collection?
Yes, it is.
Okay. Your Honor, when it comes to attorney's fees, I can state my place as to the legal fees in this case, and I'll give you a little bit more background as to why the legal fees are a little bit higher than would normally be in a typical collection case, because this is not a typical collection case, given the amount of fines and given the severity of the violations. But generally speaking, my firm performs services on behalf of the association at hourly rates of $195, $225, $285 last year. My rate this year is $295 an hour. These rates are reasonable and customary for attorneys in the Atlanta area practicing community association law. In total, my firm spent 28.2 hours of time in connection with this matter, and the association incurred $7,952.61 in attorney's fees and expenses and $264 in court costs. We did file a motion for default judgment with the court, which did in fact include an attorney affidavit itemizing those legal fees. But just to provide a little brief background for the court, we did have to serve defendant via publication because defendant lives out of the country, and that publication did confer personal jurisdiction. We were contacted and worked with a couple different agents. They're not attorneys, but they were agents on behalf of defendants who were out of the country. One agent was in Germany. Another agent was from, I would say, Soviet bloc country. The defendant in this case is essentially like some sort of Russian oligarch, if you will. And actually that the federal government has a lien filed against this property. So in order for my firm to communicate with respect to this property, with respect to these agents, we had to actually go through the Federal Office of Foreign Asset Controls. And we had to actually file an application with the Office of Foreign Asset Controls in order to speak with these agents for the defendant to have a conversation about the amounts owed, because the federal government has a priority lien. And I can't even speak to what other issues are going on with this defendant and the federal government, but we tread very carefully when these types of liens are filed. So it was a lot of communication with the government and the government agency, OFAC, OFAC, or the Office of Foreign Asset Controls, in order for us to even have conversations with the agents for defendants as to the status and condition of the properties. We continue to be in communication with these agents. They were given a copy of the motion. And here we are today. So it's a very different case than I'm usually in front of the judge in the court regarding. At the end of the day, defendant didn't file an answer. We're entitled to our default judgment. And then we hope to continue our discussions with these agents to try to get the property back into some sort of standard that's satisfactory to the community.
A couple of questions for Mr. Hill. So what's the, I guess, how large a property or how valuable a property are we talking about here?
According to an article I read that was posted about a year ago, it was, I think, 2.5 million.
Okay, so this is a significant.
Oh, these are mansions, Your Honor.
Mm-hmm.
Yes.
And Your Honor, if it's helpful, one of the things that I emailed to the court were copies of the violation letters that were sent. And on the top right-hand corner, there are photos. It might not be the photo of the entire property, but there will be photos that give you a concept of like the falling seawall into the community lake. And it'll show you kind of a pictures of the home as well.
All right, so I don't know, according to your own bylaws, do you have the ability to make repairs? The association have ability to make repairs, or have you ever attempted to make repairs? I wonder what the cost of the repairs would be versus the fines.
And Your Honor, that is addressed towards me. Is that correct?
Yes.
Okay. The documents do permit self-help. Typically for anything other than, say, mowing the grass, we would, of course, go to Superior Court and get permission to take such action, just because anything that involved. As was stated by Mrs. Taylor a moment ago, there have been communications with agents of the owner, and in the last several months, they've started doing some work. It is very, very extensive. Apparently, there's interior water damage, on and on and on. So it's not something the association would normally foot the bill. I am not an expert. I can't testify to what it would cost, but it would be a lot.
Do we know how or why the damage happened?
Your Honor, the property appears basically to have been abandoned. As has been mentioned, this has been a federal issue. The individuals, all their assets being frozen, and they basically not entering the country for various reasons.
So the property is essentially abandoned and in disrepair.
That is correct.
All right.
And there's no mortgage or lender here to foreclose. It's just sitting.
All right. Well, I've heard enough. I think judgment is warranted in the amount requested. Ms. Taylor, did you submit a proposed judgment?
I did, Your Honor.
All right, so we'll take a look at the proposed judgment and we will sign that.
Thank you, Judge.
Right. All right, if you have no further business, Ms. Taylor, Mr. Hill, you can be excused.
Thank you,
Your Honor, I'm going to stay on the line because in the other Windward case, position number 1, that's now being handled by Miss Mary Beth Sierra, there are legal fees that my firm we had that case for a little bit, and that client is moving to a different firm. But I'm going to stay on the line to assist in testifying as to the legal fees for my firm. So I'll just sit here quietly until that case is called.
All right. Let's go then to position 13. I believe is next one. That's Elite Concrete versus Richmond Hill.
Good morning, Your Honor. As stated in the beginning of the hearing, I have one witness.
All right.
I would call Micah Sasser. Good morning, Ms. Sasser.
Good morning.
Can you hear us?
I can.
Will you please raise your right hand? Do you swear the testimony that you're going to give today is the truth, the whole truth, and nothing but the truth? So help
I
you
do.
God.
I do.
And Ms. Sasser, you are the general manager of Elite Concrete, is that correct?
Yes, it is.
And from September 12th to October 2nd of 2018, Elite supplied ready-mix concrete to a company known as Richmond Hill Building Group LLC, is that correct?
Yes.
And that was done on an open account for use and improvements to 2 parcels of property, correct?
Yes.
And there remains due and owing the principal sum of $13,150, is that right?
That is.
And you have there in front of you what's been marked as Exhibit 1, a statement showing 5 unpaid invoices, is that correct?
Yes.
And as well as the invoices behind the statement, is that correct?
Yes.
And the invoices specify that they are due in net 30 or in 30 days, right?
Yes.
And the date of the last invoice is October 2nd of 2018.
Yes, that's right.
And interest has continued to accrue on that principal balance at the commercial open account rate of 1.5% per month, is that correct?
Yes.
And all outstanding invoices were for materials supplied to a property commonly known as 8 Aviation Court, located in Garden City, Chatham County, Georgia. Is that correct?
Yes.
Now, Elite has recorded a lien against that property improved using those materials, correct?
Yes.
And there in front of you is Exhibit 2 is a copy of that lien recorded at lien book 776-257 Chatham County Records. Is that right?
Yes.
And Elite has filed suit against the primary debtor to collect and perfect that lien, that being Richmond Hill Building Group, while we're here today, correct?
Yes.
And Elite is seeking judgment in the principal amount of $13,150. Is that right?
Yes.
And Elite demanded payment from the defendant, Richmond Hill Building Group, on November 28th of 2018. Is that right?
Yes.
And that demand was received no later than December the 4th. Is that right?
Yes.
And you have there in front of you as Exhibit 3, a copy of the demand letter. Is that correct?
Yes.
And also in front of you as Exhibit 3 are copies of the certified mail receipts showing receipt of the certified mailing. Is that right?
Yes.
And in addition to the principal amount, you are seeking interest in the amount of 1.5% per month from the date the demand was received by the defendant, that being December 4th of 2018, through February 4th of 2021. Is that right?
Yes.
And you're seeking that at the rate of $197.25 per month. Is that correct?
Yes.
And Elite Concrete filed suit against our firm or hired our firm to file suit to collect the amounts due. Is that correct?
Yes, it is.
There in front of you is Exhibit 4, copies of my firm's statement and the invoices associated with those collection efforts. Is that correct?
Yes.
And based upon your review of those invoices, it appears that the amount charged to collect the debt was $1,948. Is that correct?
Yes.
And originally, the amount owed by Richmond Hill Building Group was much larger and was ultimately reduced or narrowed down to this $13,150. Is that correct?
Yes.
And Exhibits 1 through 4 that are there in front of you, Ms. Sasser, are true and accurate copies of documents retained by Elite, and it's part of your ordinary course of business to retain such records. Is that correct?
Yes, it is.
Your Honor, at this time, I'd move to admit Exhibits 1 through 4.
Those were sent in advance.
They were, Your Honor, and filed in accordance with the court's instructions.
All right, I've seen those, so those are admitted.
And Your Honor, as far as the reasonableness of attorney's fees to the extent necessary, I'll state in my place that I'm a member of the state bars of Georgia and South Carolina. I've been handling open account collection of construction materials for nearly 20 years. I'm aware of the reasonable and customary fees that are owed or incurred in connection with cases such as this one, and that the fees incurred are in fact reasonable and customary and in line with the reasonable and customary rates charged in Chatham County, Georgia.
All right, so the total amount requested in
Total
judgment
amount
today.
is $13,150 in principal. Interest in the amount of $2,761.50. And attorney's fees in the amount of $1,948. I have not yet filed a proposed order, but I will submit one by the close of business today, Your Honor.
All right, if you submit a proposed order with those numbers, we will sign that.
I appreciate the court's time. Thank you very much. May I be excused?
You may be excused. Thank you all for your patience.
No
Thank you,
problem.
Judge.
Have a good day.
All right. Next one. Is Metro Trailer Leasing.
Yes, Your Honor, Allison Crane from Metro Trailer. And we have Megan Bryan. Should be on as a witness for Metro. She is there.
She is there. You can go ahead when ready.
Okay, Your Honor, Metro Trailer Leasing retained my office in or about December 2019, January 2020. We filed our complaint against All City Express and Ibrahim Kamalov. Mr. Kamalov is a personal guarantor. Your Honor has a copy of the exhibits that we submitted. He did sign as a personal guarantor, which is why he is listed individually as a defendant. We filed our complaint and amended our complaint on the 7th and 8th of January 2020. All of this was sent for service. Initially, we attempted service through the Marshal Service. We were unsuccessful. Secondary, we attempted service through the Sheriff's Department at various addresses. We were unsuccessful. We made numerous attempts to locate both the company and Mr. Kamalov. It was then around January, after our attempts, because we moved quickly on the attempts for service, we were contacted, my office was contacted by a company, Fusilier, I believe is the name. They had a power of attorney giving them the authority to speak to me on behalf of All City and Mr. Kamalov. They're not attorneys. They did not enter any kind of appearance, but they are some sort of business finance company that wanted to discuss Mr. Kamalov and All City paying Metro for the amounts that were owed. Because they had the power of attorney and it was signed by Mr. Kamalov and as a representative of All City, we did engage in speaking with them all the way up until they had him sign our acknowledgement of service, which was signed on February 14th, 2020. And we filed that with the court on 3/23. We continued to communicate with them all the way through June of 2020, at which time I was notified that they had withdrawn for whatever services they were providing him, that they were no longer the contact. And so I was left out again, not able to contact Mr. Kamalov, not able to get an actual pinpoint on All City. Your Honor's court has had sent a couple of notices to my office for non-service calendars. We cleared that up and showed that we had in fact filed our service. And that brings us here today. We received the notice for today's hearing. We made 6 separate attempts to notify Mr. Kamalov and All City of this hearing today. That was 3 addresses for All City and 3 separate addresses for Mr. Kamalov. And we did not receive any report back or any acknowledgement. We do have Megan Bryan. She is
the accounts receivable for Metro Trailer Leasing, and she is prepared today to testify as to the statements that we have provided, specifically Exhibit E, Your Honor, that shows the last amount due by All City and Mr. Karmalov as the personal guarantor.
Right, go ahead with that evidence.
Ms. McBride, if you could raise your right hand. Do you swear and affirm that the testimony you give today will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Okay, could you state your full name, please, for the court?
Megan Bryan,
And who is your employer?
Metro Trailer Leasing.
And what is your position with Metro Trailer Leasing?
I'm the accounts receivable manager.
Okay. And did you send this account to my office for collection in or about January 2020?
I did.
And as of the most recent statements provided by Metro Trailer Leasing, dated January 15th, 2020, is the balance showing of $23,197.07. Is that correct?
That is still correct.
And are there any additional charges or fees that are due and owing at this time?
Not for Metro Trailer, just your fees.
Okay. Your Honor, that's all I have for Ms. Bryan.
Question, general question. So when you're invoicing, what services specifically are you invoicing for?
All City Express rented 35 tractor trailers from Metro Trailer between November 15th of 2016 and September 23rd of 2019. So the past due balance is for rent that was unpaid, as well as any damages that were assessed when the trailers were returned.
All right. And so there were several months that were outstanding at the time that the trailers were returned?
That is correct. Right now, the balance dates back to July 1st of 2019. The last trailer again was returned in September. We issued a 10-day demand letter on the account demanding the return of the equipment and payment of balance in full. We tried to establish several payment plans. There were many payments promised that were not upheld. We extended the time we allowed for them to return the trailers by, I think it was 3 weeks. And in the end, they just said they couldn't pay. They were waiting on an insurance check and kept giving us that same excuse every week.
But eventually they did return all of the equipment.
Yes, all the equipment is returned. So the money due is just for the balance while they had the trailers.
All right. That's all the questions I have for you, Ms. Bryan. Thank you.
Thank you.
Okay. And Your Honor, I am prepared. Also, we did ask attorney's fees in our pleadings. I'm prepared to stand in my place that over the course of 14 months from the time we received this, this case in my office until and through today's hearing date, my office has expended approximately 18 hours in services, including trying to locate the defendants, attempting service numerous times, the dealings with Facilier Financial Services, drafting our pleadings, so on and so forth. At $250 an hour, which is reasonable and customary for the type of collections work here. I'm in Henry County. It's also, I believe, reasonable and customary for Fulton County. And that is where we have reached the amount of $4,500 in attorney's fees.
All right. I find that you're entitled to judgment in full for the amounts past due and owing, and in full for the attorney's fees. If you can submit a proposed judgment to Mr. Townsend, we will get it entered.
I will, Your Honor. Thank you very much. May we be excused?
You may be excused.
Thank you, Your Honor. Have a good day.
All right, I think that leaves us with Windward Community Service Association. Let me take, I need a 5-minute break. So let's everybody take a few minutes and then we'll come back and we'll have the hearing.
Okay.
Thank you.
All right, we can have all parties back online. Ready to begin.
Thank you, Your Honor. Okay, so my name is
Sierra,
Mary.
I think,
Yes, go
Ms.
ahead.
Sierra, I think you're in the driver's seat here.
Okay. So as I mentioned, my office recently took over this case from Miss Taylor's office, which is why she's on to testify a little bit later as to the attorney's fees that the association incurred from her office. And I also mentioned that we filed the amended complaint last week, and in doing that, it was more of an effort to clarify. The original complaint actually pled for all the amounts that were continuing to be imposed because there were fines being imposed on this account. And in the motion for default that was previously filed by the prior counsel, that also had additional amounts in it because those had become due from the filing of the complaint through the default. So our attempt was more of to clarify everything to a date certain since we had trial coming up. Although it was originally pled for all those amounts, they just continued to be due. So I just wanted to clarify for the court kind of our rationale behind doing that, to make it simple and straightforward for everybody to follow. But so, Your Honor, this is a case. Miss Dennis is a homeowner in Windward Community Services Association, and it is also a collection case similar to Miss Taylor's case. There are past due assessments owed on the account, which the testimony will show, as well as fines on the account. The testimony will show that she is the owner of the property, and she did admit that in her answer, at 4835 Tidewater Way in Alpharetta, Georgia, located within the Windward Community Services Association, Inc. community. There have been, in addition to that, attorney's fees and court costs and expenses incurred, which I will testify to, Ms. Taylor will testify to, and one of the property managers, Ms. Kyler, is also online to testify as to all of the fees and everything the association has imposed and incurred. The testimony of the association's property manager will set out the amount the defendant owes for the assessments that are supported in the amended complaint, the $18,845 amount plus the interest of $136.26, and all of the attorney's fees lumped together of $815, as well as the costs and expenses. With that, I will call, well, I guess that Mr.
Yes, Mr. Bastian, you wish to make an opening statement?
No, Your Honor, we're fine.
All right, we'll go right to the evidence. Call your witness.
Ms. Kyler, I will call Melissa Kyler, Your Honor, to testify. Please raise your right hand. Do you swear from the testimony you're about to give to be the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Okay. Please state your name for the court.
Melissa Kyler,
And Ms. Kyler, who is your employer?
Access Management Group.
Okay, and what is your title with Access Management Group?
I'm one of the community managers for the Windward community.
Okay, and what is included in your responsibility as one of the managers for Windward Community Services Association?
One of my responsibilities is to complete inspections. So we inspect the property, we take photos, document any issues that are there, and communicate with the homeowner, send notices, and if there are any fines, we post them on the account.
Okay. In addition to that, do you do anything with just general accounting records?
Yes, we do. We manage and maintain their accounting records and post information, any checks or any information received.
Okay, checks. What do you mean by that? Checks from whom?
From the homeowner.
Got
If
you.
the homeowner submits a payment, we post those on their account.
Okay. Can you kind of identify or explain to the court the property inspection process?
Yes. So we visit the community and we drive around, inspect homes to make sure that they're in compliance with the association's governing documents. And if there's anything that is not in compliance, we will send a notice. We'll take a photo, document it. We'll send a notice to the homeowner and send communications and follow up with them.
Okay. And then you mentioned just generally accounting and collecting payments from homeowners.
Correct.
What are those payments for?
Association fees, and if there are fines as well.
Okay. How are the association fees established?
Through the association governing documents, Article 8 in the declaration allows the association to assess association fees.
Okay. And are those fees assessed to all the homeowners, or how is that done?
All homeowners are responsible for paying association fees.
Okay. And according to your records, do you have record of the defendant in this case, Miriam Dennis?
Yes.
Okay. And is she in your records as one of the homeowners?
Yes.
And her address?
Is 4935 Tidewater Way.
Okay. And that's within the Windward community?
In Alpharetta, yes, Windward community.
Okay. And are you familiar with Ms. Dennis's property?
Yes.
And are you familiar with her accounting records?
Yes.
Okay. Your Honor, we will tender the declaration that Ms. Kyler mentioned as Plaintiff's Exhibit 1 or A.
All right, any objection?
I'm not quite sure which one is the declaration, Your Honor. Is it Exhibit A to the complaint?
To the amended complaint. Actually, I might have it as B here. Let me just.
I believe it's Exhibit B to the amendment.
Exhibit B to the amended complaint. I just went out of order.
Okay. No objection, Your Honor.
All right, that exhibit is admitted.
Thank you, Your Honor. Ms. Kyler, you mentioned the declaration is kind of how the association, the board establishes what's owed by homeowners. And you've already talked about Article 8 in this document. What specifically is, how does the association board impose these assessments, the regular assessments?
We send out notifications. Basically, the association establishes a budget through the governing documents. It allows us to establish a budget, and we determine the amount through that budget, and a homeowner receives a notification of what's due annually. So we assess notices annually. We assess association fees annually.
Okay, and I'm going to back up real quick, just in your role with Windward. How long have you been a manager for Windward?
With Windward, I've been a manager for 4 years.
Okay, and that is you personally or Access Management Group?
Access Management Group, and me personally, I've been with Windward for that time.
Okay, both. Okay, so then is it part of your responsibilities once the board establishes this budget to notify homeowners?
Yes.
Okay, and what is the process for that? What do you notify them of?
We notify them of the amount by sending out a statement that is due. We also send out the budget annually. Prior to sending out the notice, we send out a budget to the homeowners to let them know what to expect for the next year.
Okay. Is this the same process that you've done for Ms. Dennis as a homeowner?
Yes, we do the same process for every homeowner.
Okay, and if a homeowner does not pay their annual assessments, then what is your process?
We send out a late notification, letting them know that there's a past due balance on their account.
Okay, and how often do you do that?
We do that monthly.
Okay. And does the declaration allow for these assessments to be imposed against the owners?
Yes.
Okay, has Ms. Dennis paid all of her regular assessments that are due and owing to Windward?
No, she still has a balance of $475.
Okay, and do you know what year that is for? What year's assessments that is for?
2017.
Okay, and is that equal to the 2017 assessment?
Yes.
Okay, and did you notify Ms. Dennis of the annual assessment that year in 2017?
Ms. Dennis was notified by the previous management company.
Okay.
And we, Access Management and Windward Community, sent a late notice reminding her of those assessments on October 5th of 2017, because we took on the property in September. And we also sent another notice on November 21st, 2017.
Okay, and go ahead.
And that notice included any past due balance, which was part of the association fee. And there were some other fees there. So the total balance that was on the notice was $602.50 at that time.
Okay, and does the declaration give the association the authority to impose those additional fees that you mentioned, interest and
yes,
and cost? Okay, and where is that in the declaration?
That is, as far as fees, that is in section 8. I'm sorry, section 9, article 9 of the association.
Okay. And did the association, and by the association, then you impose the interest that was allowed pursuant to that section of the declaration?
Yes.
Okay. Once you sent those late letters to Ms. Dennis, did you receive payment from Ms. Dennis for that 2017 assessment and interest?
We did not.
Okay. Subsequently, did you send notice to Ms. Dennis of additional years assessments like 18, 2018, 19, 20?
Yes.
Okay, and were those all paid?
Yes, they were.
Okay, great. So it's just the 2017 $475 annual assessment that was not paid.
Yes, correct.
Okay, and then the associated interest and fees. Let's talk about the condition of Ms. Dennis's property. Did in your monthly inspections that you do, or the other weekly drive-throughs, what did you note of Ms. Dennis's property?
We noticed that Mrs. Dennis's property needed to be, her driveway needed to be pressure washed. It had mildew on it. And so we sent a notice about that.
Okay, and was the violation corrected?
No, not at first.
Okay, when did you send notice of that?
That was back in August of 2017.
Okay, and then subsequently, what action did you take?
We sent another follow-up notice to Ms. Dennis.
And when was that?
It was 30 days later.
Okay, and did she then correct the violation?
She did not.
Okay, so then go on and tell me the next steps that you took as the manager.
So essentially, we sent a final notice to Ms. Dennis, and essentially the pressure washing did not occur. So at that point, we actually don't send people to collections right away. We try to give them an opportunity to resolve it.
Okay.
But we were not successful in having her pressure wash her driveway. So time passed, and then we sent her to collections in January of 2018.
Okay. I am going to direct you, Ms. Kyler. You've already testified on Exhibit B, the declaration. I'm going to have you look at Exhibit C that you have. Do you have that in front of you now?
Yes.
And Mr. Bastian, this is all that is attached to the amended complaint, the exhibits?
Okay, so it's Exhibit C of the amended complaint?
Yes, it is.
Okay.
Okay, Ms. Kyler, can you identify this document for the court, please?
I have Exhibit C.
Yeah, can you just kind of tell the court what this document is?
All right, give me one more second. I'm sorry. I'm trying to pull it up on my computer. I apologize.
No, it's fine.
Okay, I have it. I'm sorry.
That's okay. So we're looking at Exhibit C.
Yes, ma'am. Okay, my computer's opening it. It's just taking a second. Okay. For some reason it's taking forever. Okay. I'm almost there. I'm having a hard time opening the document. I'm so sorry.
It's okay.
Not working properly here. I'm at Exhibit B. So, okay. I am at Exhibit C, which is the homeowner's account statement.
Okay. And the homeowner's account statement, is this a document that you keep as the property manager?
Yes.
And this is prepared by you and your office?
Yes, it is.
Okay. And this shows Miss Dennis's information on it?
Yes, it does.
Okay. And what all is contained, what type of information is contained on this document?
Ms. Dennis's association fees, if there are fines, which there are, delinquent interest, attorney's fees, interest, and her total balance.
Okay. And is this a true and accurate copy of Ms. Dennis's account ledger?
Yes, it is.
Okay. And looking at this document, well, Your Honor, I will tender a plaintiff exhibit C.
I'm sorry?
Your Honor.
All right, Exhibit C is admitted.
Okay. Ms. Kyler, in looking at Exhibit C, the ledger, does it show the 2017 assessment that was not paid?
Yes.
Okay, so this document basically starts at the beginning of time when your office started managing Windward Community Services.
Correct. Yes.
Okay. And you said that this document outlines all fines, anything that's owed or coming due or paid on this account would show on here.
Correct. Yes.
Okay. And does it show, as you testified to, that she has paid her 2018 and 19 and 20 and 21 assessments?
Yes.
Okay. So it's really just that 2017 amount. And then the fines. Let's go back now to the condition of the property. You said that you guys had sent letters, several letters, after she did not comply. Then you sent a fining letter. Tell me about that.
Basically, the fine notice essentially gives Ms. Dennis an opportunity to resolve the matter before fines are assessed. And if they're not assessed, it gives her a time frame in which we're going to post fines to her account.
Okay. And did she resolve the issues at that time with her property?
She did not.
Okay. And you said that the issue was a maintenance issue involving mildew and dirt on her driveway?
Correct. Mm-hmm.
Okay. And at what point did she correct a violation, or did she correct a violation?
She recently, I would say in 2020, corrected the violation.
Okay. So it started in 2018 and corrected in 2020. Okay. Mm-hmm. Tell me about the fines that were imposed and she did not correct it.
You want the total amount or just?
Let's talk about the daily fines.
Okay. The association charged, at that time, we charged about $50 per day. And it was from the time that we sent that last third notice and we gave her an opportunity until we submitted, and basically it continued until the pressure washing was completed.
Okay. So if you look at Exhibit E, if your document will.
Yes. Mm-hmm.
Okay. Can you identify, this is a group of documents, can you identify these for the court?
Yes. Okay. One moment.
Sure.
Just get to, okay. Yes, these are the notices that we sent to Ms. Dennis.
Okay. What notices?
The maintenance, first notice was a maintenance notice.
Okay.
And all of them were maintenance requests.
Okay. And are these true and accurate copies of the letters that were sent?
Yes.
Okay. And these are sent out by your office and at the property managers, yours and the other manager's direction?
Correct. Yes.
Okay. And on these letters, do you guys give the owner any sort of explanation as to what needs to be done to fix their property?
We do. On the notice, it basically explains to please have your driveway cleaned of mildew and dirt. And we, remind them that cleaners are available at hardware stores.
Okay. And do you guys attach a photograph of the violation?
We do. We have a photograph attached.
And was there an issue with the photograph attached to the first letter?
There was. Mm-hmm.
Okay. Explain that to the court.
It was accidentally the wrong home photo was attached to the notice. So we corrected that and we sent a new notice and gave Ms. Dennis an opportunity to resolve it.
Okay, and she still didn't.
Correct.
Okay. Did you ever receive any communication from Ms. Dennis after getting these letters?
No.
Okay. Your Honor, we will now tender plaintiff's exhibit. I'm going to just go with the order that we have here. It's E, which are the compilation of the letters.
Any objection, Mr. Bastian?
My objection, Your Honor, is that we did not receive those. So as to whether or not what the plaintiff states that they had sent, I have no objection, but my objection is that we haven't received it.
All right, so those are admitted.
Okay, thank you, Your Honor. And Ms. Kyler, you said that eventually Ms. Dennis did correct the violations?
Yes.
The violation, the maintenance violation in 2020?
Yes.
Okay. Okay, 1 second, Your Honor. Okay, Ms. Kyler, you said that the letters warned Ms. Dennis that she would be fined, eventually she'll be fined $50 per day, right?
Mm-hmm.
I believe you said that the first letter went in August of 2018. And can you tell the court when were fines finally starting on this account?
So the last notice was submitted in January of 2019, just stating that, due to the failure to comply, fines will be imposed on the account. So that was January 8th of 2019.
Okay, so 5 months after notifying Ms. Dennis the first time of her violation, then fines started on this account.
Correct.
You gave her 5 months to remedy. Okay. And did the association impose $50 per day fines after that point?
Yes.
Until it was corrected? Okay. And what is the total amount of fines the association is seeking?
As of today, it's $18,300.
Okay. And that's for fines from the January 2019 through January 2020 and when it was corrected?
Yes.
Okay. At the $50 per day amount?
Yes.
Okay. And those amounts are all shown on the association's ledger?
Yes.
Okay. And does the association in their governing documents have the authority to require owners to maintain their property?
Yes.
Okay. And can you identify that for the?
Yeah, Article 4 of the governing documents requires that the homeowners have an obligation to maintain their home.
Okay. Does the association enforce this provision throughout the entire community?
Yes, we do.
Okay. And how many homes are in Windward Community Services?
2,500 homes.
2,500
I'm
homes.
sorry, 2437 homes.
2437. Okay. And it is your job and the other manager's job part of your job to go around and do these inspections, notify the board and take photographs and then notify owners. Okay.
Correct.
And is this violation, was it only Ms. Dennis that you've notified of a violation, or do other owners have violations?
There are many other owners. There are other homeowners that have this same violation, and we notified them and followed the same process.
Okay, thank you. As far as you mentioned earlier that there's interest on the account for only the unpaid $475 amount, and the declaration you said allows for interest. Is that interest rate at 7%?
Yes.
Standard rate in Georgia? Okay. And do you have the interest total?
It's $136.26.
Okay. And has the association incurred attorney fees, court costs, and expenses in its efforts to collect this past due amount and to get Ms. Dennis to comply with the covenants and collect the fines?
Yes.
Okay. And has the association paid those attorney fees as they became due?
Yes, they have.
And did they previously hire the law firm of Winter, Capriola, and Zinner to assist with collections in this matter?
Yes.
They paid fees to Winter, Capriola, and Zinner?
Yes, they did.
Okay, and they now, Windward has hired my firm, Coulter and Sierra, to assist in collection of these matters?
Yes.
Okay. And does the declaration allow for the recovery of the reasonable attorney's fees the association incurs?
It does, yes.
Okay, and did the association also incur expenses, filing fees, service fees, in its efforts to collect these past due amounts?
Yes, they did.
And does the documents, the governing documents, also allow for the recovery of those amounts?
Yes, they do.
Okay. Your Honor, I will state in my place as to the attorney's fees that my office has billed, and we will call Ms. Taylor in just a few minutes once Mr. Bastian has had an opportunity to cross-examine Ms. Kyler. Give me just 1 second, though, to make sure I don't want to touch on anything else. Oh, one more question, Ms. Kyler. And you said that your office had sent Ms. Dennis several late letters, I think 2 late letters, and then 3 or 4 violation letters for her property. And then at what point how did Winter Capriola become involved in this matter?
We turned the account over to Winter Capriola Center. So then at that point, they communicated, they sent a communication to Ms. Dennis about the amount due and the process.
Okay, and was that August of 2018?
Yes.
Okay, and after that point, did you receive the payment or anything from Ms. Dennis?
No.
Have you, as of today's date, received the payment for that $475 amount or the fines?
No.
Okay, so the violation has been corrected. It's just really the money owed that we're seeking today.
Yes, correct.
Okay, Your Honor, at this point, that's all I have for this witness. I have tendered the declaration, the violation letters, and the ledger of the accounting ledger of Ms. Dennis. Just want to make sure that you have those tendered.
Yes, I have them.
Okay.
Bastian, your witness?
Thank you, Your Honor. Afternoon, Ms. Kyler. Can she hear me? I didn't hear a response.
Yes, she nodded. She
Oh,
nodded.
she nodded. Oh, I'm sorry. We're used to doing different things at time, looking and talking to you, so I didn't see you. I'm sorry. Ms. Kyler, remind us, when did your firm start to manage the Wynwood?
September 1st of 2017.
Okay, and as part of the handoff or the transfer, are you given prior records?
Yes.
Okay. Now, up until that point, has Miss Dennis ever been late?
We show that she owed for 2017's dues. So that's, as far as that's concerned, yes, she was.
So the 2017 dues, and you're talking about, we now know that you're talking about the $475. Is that correct?
Yes.
Okay. Now, prior to the $475 on 2017, do you show that she's ever been late?
I would have to go back and look at the records. I only have documentation I only have her in front of me on 2017. So,
okay. But for 2017, you alleged 2017 that was owed prior to your firm coming. Is that correct?
Yes.
Okay. So that means that that's the only violation. That's the only assessment that you know of that.
Correct.
Yes. Okay. So if Ms. Dennis were to allege that she's never been late, there's nothing to contest that.
Correct.
Okay. And as a matter of fact, your ledger shows that she's paid consistently. She receives a bill and she pays it right away. That's what your ledger says from going back to 2015. Okay. And in addition, she's never had any violations either that she's paid for that I see.
Okay.
Okay, so you would have to agree with me, I guess.
She currently is she was in violation. So prior to that, I don't have any documentation of her being in violation.
And let's cut to the chase. There are 2 things involved here. 2017 for $475, and secondly for the driveway. That's it. There's nothing else.
Correct.
Okay. And there's never been any violations of anything at all by Miss Dennis, right?
Correct.
Okay, now let's hone in on that 475. When was the first time that anyone ever told her that she put the 475?
When our firm took over, we notified her of a past due balance on October 5th of 2017.
And that October 5th, 2017 balance, what did it say? Did it say that you owe $475? What exactly did it say?
It stated that she had a past due balance of $602.50.
Okay. So now, had you been in communication verbally with Miss Dennis?
Our documentation requires that we send a written notification to the homeowner about their balance.
Okay. So Miss Dennis inquired as to the 475, where it was, as to what amount she owed, but no one was able to give it to give her an amount. Do you show anything different in your records?
Do I show anything different in my records in terms of Miss Dennis contacting us or the balance?
As far as the association advising her that she owes $475, and because of the $475, she has X amount that is owed.
Yeah, I mean, we notified her on October 5th of 2017. So
how much did you advise her that she owed?
We advised her that her balance was $602.
When she asked why she owed $602, did anyone tell her that she owed $475 plus some other explaining fees? Did anybody do that?
If she contacted our office, she didn't speak with me personally, so I can't attest to a conversation I didn't have with her directly. But I can tell you, if she contacted our office, we would have given her a breakdown of all the fees.
Same question again. Miss Dennis alleges that she contacted to find out why did she owe $602. Well, did anybody respond to her and tell her, yes, you owed $475 for 2017 and something else? Did anyone respond to her?
Your Honor, first I'm going to object in that there's no evidence or even any testimony that Ms. Dennis ever contacted the association. In fact, to the contrary, Ms. Kyler said she had never heard from Ms. Dennis previously in testimony.
So he's put a qualifier in there. He said she alleges that she contacted. So it's not an established fact, but I think it's just a precursor to the question.
Okay.
And I understand the substance of the question, so I'm going to allow it.
Ms.
It
Kyler?
sounds like the bottom line is that there is no record of any response to any question raised by Ms. Dennis.
Right. That's exactly it.
Okay, I've got it. So you can move on to the next one.
Okay. Ms. Kyler,
yes,
do you have any correspondence at all sending Miss Dennis a bill for $475?
Yes. Well, I have, the only correspondence I have is the late notices that we've sent because the previous management company sent that notification out.
Do you have the notification for $475?
The statement, I do not have the statement that they originally mailed out to her. We have, again, the notice we sent, and we have the statement that we received from the prior management company showing that the balance was not paid.
Had your association questioned itself, why would someone that paid $475 every year not pay this one?
Well, that's why we sent her a reminder notice asking her for payment on October 5th of 2017 and November 21st of 2017. That's why we sent it.
But it didn't have $475 on it.
I'm sorry?
It didn't have $475 on it, right?
At that point in time, that's what the balance was showing. So we sent that notification to her. If she contacted our office, there are 3 people that work in our office, and asked for a breakdown, we would have given her the details of that.
Okay. So now let's look at your Exhibit C, Ms. Kyler, which is Wynwood Community Service Association's breakdown.
Yep.
Okay. Now, I see 8/31/2017, $485. Is that right?
Correct.
Is that what 475 meant, or is that something else?
That was what the prior management company's balance showed. It was 485. So I mean, I can certainly pull the prior management company's balance, but that was what we had on the records when we took over the management of the community.
We've been asking since the beginning of the litigation for 475. No one has produced it to us, but that's neither here or there. Now, the next thing is there is an amount for $625. That's 2/1/2018. You see that?
There is amount of what? I'm sorry, repeat that.
There's an amount for $625.
Yes. I see that.
2018. You see that?
I do.
Okay. So is that a new that's
The dues went up. Yes, the dues increased in 2018.
okay, so that's the dues that increased. That's the new dues for 2018. You said.
Correct.
Okay. Now, and I see in February 2018 and June 2018, she paid $313 and $312.
Correct. But she actually paid them after they were due. They were due on the 1st and they were considered late on the 15th. So she actually paid on the 20th. The balance.
Or are you sure that, or is that when it was allocated?
That was when we received the payment. We received the payment on February 20th, 2018 of $313.
Your discovery shows a check for February 1st, 2020. Are you aware of that for $313? The check is dated February 1st.
The check may have been dated February 1st, but that we post things when we receive them.
Okay. Are you aware as well that there was a letter sent to the homeowners telling them that they're able to break up the payments into twos?
Yes.
And did that mean that they would have been charged fees if they break? Were they told that?
They were. I personally wrote that letter. So they were sent a notification along with their dues. So she must have received the dues because along with the dues, there was a letter that said the dues were increasing. This is the new amount. It's due on the 1st. It's considered late on the 15th. And this is what, interest will be accrued if it's received after the 15th of February. And the same thing goes for May 1st. So yes, because the payment was actually due on May 1st of the month, and it's considered late on May 15th. So yes, she did receive that. We sent it out to every homeowner in Windward. And if she received the coupon, she received that letter because it was included in that packet.
So let me ask you this question now. When do you charge interest on that $313?
We actually wait until after the 15th. We wait because, it's due on the 1st. We give them a grace period of the 15th. And if it's not paid by the 15th, then we post interest.
So you're saying the $494 that's charged after that, it's for the payment of $313?
It's a combination because she was also receiving interest on the other payment that was not due because it's 7% per annum and it's each payment.
And how much would the interest be for the prior one?
I mean, I can do the math really quick if you're looking for me to do that, but it's interest accrued on both payments essentially because it's every month we attach interest for each payment that's not paid.
We'll get back to that through Ms. testimony. But when would be the next assessment after the 625? Now that's the new amount. When's the next time that
the 625 was broken up, as you stated, into two payments. So the first payment was due February 1st, and it was considered late on the 15th. The second payment was due on May 1st, and it was considered late May 15th.
Okay. So when would the next payment be due?
In February of the next following year, 2019.
Okay. Did she pay that?
She did.
Okay. And she continued to pay the new 625 throughout?
Well, yeah. So in January of 2019, she was assessed the 625, and it was paid. It was due on January 1st, but it was paid on March 15th.
And then I'm not belaboring the point anymore. Has anyone after even told her what about the 475?
Again, we sent out a notice. We sent out 2 notices in 2017 notifying her of it. If she contacted our office and spoke to one of our representatives, we would have given her a breakdown at that point.
If I were to tell you that she contacted the office to ask for a breakdown, but instead she was sent a bill for 602, would you be able to tell me something different? Would you say no? I mean, how would you respond to that?
Well, if she contacted our office, she would have spoken to a representative and we would have given her information. We wouldn't have just emailed her a bill without having a discussion if she contacted our office. So I speak to people all the time. So that, I mean, we wouldn't have just sent her another bill without having a discussion with her. But I didn't personally speak with her.
Because she kept paying every bill, every time, all the time, except for this one bill. There had to be one reason. But anyway, I'll move on. Let's move on to the driveway.
Okay.
When's the first notice that you ever sent her for the driveway?
We sent her a notice in July of 2018. July 22nd.
July 22nd. Do you have a copy of that notice?
I do.
Okay. Are you looking at it?
I am.
Okay. And is that the one that had the wrong?
It did. Yes, it did. Yes.
Okay. All right. When's the next notice that you
We sent another maintenance request notice with the correct driveway on September 20th of 2018.
Okay, and you have a copy of that in front of you?
I do.
Okay, and and was that sent certified mail? How was that sent?
This notice was sent regular mail.
Okay, and what are the driveway doors? What do they look like on that one?
They have a different detail than the other. It's a different picture.
Describe it to me as you look at it.
There is a wood detail at the top that's curved, and there are it's like a regular panel garage door versus the other garage door, which is more detailed.
So there's one garage door.
There are 2 garage doors in each photo, but they are different garage doors.
And the third letter that you sent, when was that?
The third notice was sent on November 27th of 2018.
Okay. And is that the same garage doors on there?
There's no picture, but it's the same, referencing the same violation.
And how was that sent? Was it sent certified mail?
This one was sent. This one was sent certified. No, this one was sent regular notice. There's no certified. The last notice, the fine notice, was sent certified mail, which has.
Let's see the final notice. When's the final notice sent?
The final notice was January 8th, 2019.
January 8, 2019.
Correct.
And that one was certified mail?
That one was certified mail, and it had the same picture as the second notice that she received, which was the correct driveway.
Okay, do you have, do you know if she signed for it?
I don't believe she's signed for it.
I mean, as a matter of fact, do you have notice that she received any of these?
The only way we have notice is if the mail was returned to us. If the mail is not returned to us, we can only assume that she received it. Otherwise, I mean, if it was returned to us, we would assume there was a wrong address. But many homeowners do not sign for certified letters, so that we can't take that as an indication that it wasn't received.
Okay. So when was the driveway pressure wash?
In 2020,
And by that time, you had started litigation, is that correct?
correct.
Okay. If I were to tell you that she alleges that she only knew about the violation because of the litigation, would you have something different to tell me?
I would, because we use the same exact address for the notices that we did for mailing her dues, and she paid the dues.
But it was repaired in 2020, right? It was fixed in 2020, right?
Yeah, but she received the notifications to the same address that she did the years that she paid. And her address hasn't changed.
But in 2020, I was in the picture.
I understand.
If I tell you that I'm the one that made it clarify, and that's when things became clear, would you have anything to contest that?
Contest that we didn't mail it to her? Is that what you're asking?
Did not know about it.
I mean, we sent out proper notification.
Besides yourself, who else would have spoken to Miss Dennis about in your office?
David Hill?
Okay, is David still in your employ?
Yes, he is still working with Access Management in Windward.
Is he available to be cross-examined today?
I'm not sure. I need to check with him. I'm sure he could be available if we needed to.
Well, if you wanted to call a witness, you could have. To have a witness, Mr. Bastian. So we're not going to have any surprise witnesses for either side.
No, Your Honor. We didn't know about anything till this morning when we got a mail. You know, we got the mail Thursday. But that's not the point that we're going at all, Your Honor. Okay. But the point we're trying to make is that she didn't know about it, and the conversation. She'll testify. It's much different than what's alleged. But when my firm was retained, she did fix the violation in 2020. The last question I have for you, Ms. Kyler, is aside from what's been provided to us, all of them showing anything but 475, can you think of any other document that she might have received that has the 475 amount on there?
I know that, well, from us, there wouldn't have been a document that had 475 listed. But I will state that we communicated with her that there was a balance due. So that's.
But in preparing for this litigation, okay, or preparing for trial today, okay, had you find anything that, or any notice sent to Miss Dennis showing 475 is due, please pay it?
I do not have documentation of that.
Thank you. Nothing further, Your Honor, for now.
Here, any redirect?
Just briefly, Your Honor. Ms. Kyler, you said that you and Access and David started managing Windward in 2017.
Correct.
I believe of 2017, September 2017. Just to kind of go through the process of, you testified earlier that the board establishes a budget.
Correct.
How are the homeowners notified of this budget each year?
We actually send out notifications to every homeowner, and in some cases, we email them, and in some cases, we mail them. At that time, I can tell you, we were so new, we didn't have a lot of email addresses on file. We mailed the notification to every homeowner. Okay, so when there's a budget established, we mailed that notification of the 625 to every homeowner in Windward.
Okay, and is that a standard procedure of notifying homeowners of any annual budget?
Yes.
Okay, and then aside from notifying owners of an annual budget, what is the process to notify individual owners of, you mentioned like some sort of coupon or something. What is that?
We mail a statement to the homeowner stating that whatever their balance is due. So if it's for 2018, it was 625. We mailed out a statement in December of 2018 notifying the homeowner that there was a balance due starting for next year. And at that time, we notified all the homeowners that there was going to be broken up into 2 payments, as I mentioned earlier.
Okay. And do you have, this isn't the only account, this isn't the only ledger in Windward. You said there was close to 2,500 homes.
Correct.
Is the $475 amount that was due in 2017 that you're showing due in 2017, was that standard across the board for every single homeowner in Windward that year? Yes. And what was the due date based on your knowledge of what was turned over?
Based on the due date and based on my knowledge, it was February 1st. And at that time, there was only 1 payment allowed.
Okay. And had owners in Windward paid $475?
Yes.
When y'all took over months into the year?
Yes.
Had the majority of owners paid that?
Majority of homeowners had already paid the $475. Yes.
Okay. So while you don't know for sure that Ms. Dennis received an actual coupon or notice, you know that other owners paid this amount that had been billed to every homeowner?
Yes.
Okay. And then since you showed the prior firm before turning it over to you showed a balance, you then sent a late letter based on that?
Yes, we did.
Everything that was due on the account, which you said earlier included the $475
Correct.
plus any interest and late fees or fees.
Correct.
Okay. Just wanted to clarify that. Your Honor, I think that's all with this witness at this point.
I've got one more question, Your Honor. The fees that are collected, as far as the when it comes to the document that's sent to that you pointed out before, that is, let me see the name of it I'm looking for exactly. I'm getting to the first page. I want to see it exactly. The Declaration of Covenants and Conditions and Restrictions for Windward. That you pointed to earlier?
Yes.
Okay. Tell me a little bit about this. It's on page 16, it says special assessments.
Mm-hmm.
It says here that the amount is not to exceed $300 in any one fiscal year.
Yeah, that's for special assessments, not association fees. So there's 2 totally different things.
Tell us.
Well, homeowners are assessed association fees or assessments. And then there's sometimes can be a special assessment where homeowners charge specifically a certain amount that's over and above the budget, which is not what occurred in this case.
Okay, which portion directs the assessment that happens in this case?
Section 9 is where the association has the authority. Article 9 is where the association that has the authority to assess assessments to all homeowners.
Does it say how much?
It does not.
So they could pick any amount that they want then.
Correct, they can.
Uh-huh.
But it also does state, let me clarify that, it does state that it has to be based on the association's budget that they establish, and that's how they come up with the dues amount, which is also in that section. And that's how we determine the amount.
How did they come up with the amount for this one?
They based it on the association's expenses, historical data, and any projects that they know they needed to do for that year or the next year.
Okay, and as far as attorney's fees, which section grants you the authority to seek attorney fees?
It's, give me a second. Okay, it's within the same section, but further down, so. It also, there is also a section, so section 4, section 4 is where we can assess attorney's fees.
Section 4.
Mhm.
It's article.
It's the last paragraph of section 4.
So which article?
Article 9.
Article 9.
Article 9 still,
Yeah.
all right. Good. Okay, and it says that the attorney's fees has to be also be reasonable, right?
Yep. Yes.
Okay, so, I mean, I know the attorneys are going to testify before, but we have $475 that's start. But out of the $475, you're seeking to get $475 and you're looking at a violation, you're looking at the court to impose nearly $30,000, if my math is right, $18,000 plus attorney fees about that you're seeking today for the $475 and the one violation.
Mhm.
You think that's reasonable?
I think that the matter went on for a long period of time. The association has incurred these fees to try to collect or to try to resolve the matter.
But yet there's not one bill for 475 that was given to her, not even one. I have nothing else, Your Honor.
Sierra, anything else?
Not for her, Your Honor. I'll call.
I have a couple of questions for Ms.
Okay.
Tyler.
Your Honor, I'm gonna be shifting to another computer. You could talk, I could hear you guys because this battery's gone. But it's already on. It's already on. It's already on. You could talk. I could hear you.
All right. So Ms. Kyler,
Yes, sir.
who is it that decides whether a fine should be issued and the amount of the fine for something like this deferred or moldy and mildewy driveway?
It's myself and David Hill. We both co-manage the community.
All right. So it was you and Mr. Hill that made the decision that you needed to impose a $50 a day fine.
Correct. Yes, yes, Judge.
All right, and tell me what the authority is to impose a $50 a day fine.
Basically, if we are not seeing that the homeowner has resolved the matter within the time frame that's set out in our, because we actually have rules and regulations that state the fining procedure. And so we followed that procedure with the allotted number of notices and communications. If the homeowner doesn't respond or take care of the actual violation, then we fine the homeowner.
Where is this these rules and procedures? Where are these rules and procedures located? I don't see it.
There are guidelines, but it actually, the association governing documents allows the association to create rules and regulations to clarify how the procedure is handled. So, I mean, I can certainly get them to you or have Mary Beth get them to you, but they clarify the procedure for finding a homeowner.
And is this simply an internal procedure or is this procedure available to homeowners?
This is a procedure that we actually send out to homeowners on a regular basis, pretty often. We remind homeowners often.
All right, and are these procedures, are they incorporated in bylaws or some document that is?
The declaration, I'm sorry. The declaration allows the association to create these guidelines or rules and regulations to clarify the process. So yes, it is in the declaration.
And these guidelines set the amount of the fine?
Actually, the declaration in Article 8 sets that. It allows the
But
associate.
it allows the fine, but I'm talking about specifically the amount. So who says it's $5 a day versus $500 a day?
The board of directors actually determines that.
All right, so there's not anything in the rules and regulations that specify an amount for this violation, just that fines may be imposed, and it's ultimately the board that decides the amount of the fine.
Actually, there is, in the rules and regulation, it stipulates the amount of the fine and how often the fine will be imposed, but the board up front has decided this procedure. But it is determined by the board, not by myself or David Hill.
So the rules and regulations specify the amount of the fine, but that was determined by the board
Correct, yes.
in promulgating the rules and regulations.
Yes, sir.
Okay, so you sent out the notice. I understand there's going to be a dispute as to whether she actually received the notice. You sent out the notice and it says $50 a day fine. What further communications did you have with Ms. Dennis about the fines or the amount that was accruing?
Well, we actually sent out 2 notices before we sent out the fine notice.
Right, but I'm talking about, my question is very specific. After that final notice that says we're going to impose $50 a day fine, what further communication was there with her before this lawsuit about the amount of the fines or the fact that they were accruing? You see what I'm getting at?
Yes, I do. The only communication we send out is a late notice. We send them out monthly. So when the fines were accrued on the account, if there was any further balance, we would have sent her a late notice. But outside of that, there is no other additional communication.
All right, so does the late notice, because again, I don't have any late notices in the record. Does the late notice reflect an accrual of fines?
It simply just documents a balance due. It does not actually break down the balance, as I stipulated earlier.
So she would get a notice then, and again, we don't have these notices in the record. She would get a notice a month after that fine letter that would have $1,500 added. Is that correct?
Yes, yes, Judge.
But no specification as to where that $1,500 came from.
Yes, Judge.
Okay. All right, that's all the questions I have for you.
Okay, just briefly, based on that, Your Honor, I don't know that it's worth all going back anyway. I think we can move on to Ms. Taylor.
All right.
Thank you, Ms. Kyler. You can mute yourself if you would like. And Ms. Taylor, call you to the stand now. Thank you for sticking around for so long. I know you've had other stuff to do too.
Happy to do it.
Okay. Your Honor, Ms. Taylor is an attorney licensed with the State Bar. I'm happy to swear her in if you would like, but she is licensed with the State Bar and she can testify to all of that.
You can testify in your place.
Good afternoon again, Judge. I can say in my place that I'm an attorney duly licensed to practice law in the state of Georgia. I'm a partner with the law firm of Winter Capriola Zenner LLC, and I've been practicing since 2003, particularly in the area of community and condominium association law. My firm has represented Windward Community Association Services in connection with this matter since August of 2018. In August of 2018, this matter was turned over to my firm to start the formal legal collections. There is an affidavit that was filed, I believe it was last Friday. And that affidavit does include my firm's billing statement, and I'm happy to go through that, and as well as to state in my place. But I just wanted to point out to the court that the billing statement is there if Your Honor wants to take a closer look at it.
I have
But
it.
in 2018, before this lawsuit was ever filed, we sent a demand letter to defendant outlining the amounts then due and owing. That demand letter was sent to the defendant at her property address, the 4935 Tidewater Way address, on August 9th, 2018, and stated that at that time she owed $661.57. We never received a response from defendant to that letter. It was sent United States certified in first class mail. We also then on October 15th, 2018, sent her what we call a notice of lien letter, or a second demand letter, stating, we haven't heard from you in response to the first letter. We are now going to file a lien on behalf of the association against you and your property to collect the amounts that's shown due and owing by the association. Unfortunately, again, that was sent certified in first class. We did not receive a response from defendant to that. So then the board of directors for the association, acting through the management, authorized us to file the lawsuit. Prior to filing a lawsuit, we do a bankruptcy search. We do a title search to confirm ownership. We filed the lawsuit. We perfected service on defendant. We did file a motion for default judgment because initially defendant is default, as Your Honor knows. We prepared to attend a hearing that was in it was in October 1st, 2019, based upon defendant's initial default. My partner, Mia Yee, attended that hearing pursuant to the notes on the billing statement. She met with counsel for defendant, who was probably just at that point in time, his services were enlisted. She agreed to continuance. After that continuance, there was communications between my office and counsel for defendant initially in an effort to try to get this matter resolved. Unfortunately, there was a lot of emails and phone calls back and forth, which Your Honor can see on the billing statement, providing breakdowns of amounts owed, trying to work something out. Nothing really happened. So defendant filed a motion to set aside and open their default. I did attend that hearing. I had stepped into the case for Ms. Yee. I attended that hearing before the court. We had a full, I think the hearing was about an hour or so on the defendant's motion to open default. The court granted it based upon the errors of not the current attorney, but the defendant's previous attorney. After that hearing, myself and counsel for defendant, we talked on the phone a couple times. We sent several emails back and forth. We talked about mediation as a possible alternative and had some discussions about a possible settlement framework to resolve this matter. Obviously, we were not able to resolve it. And so we're here today. So this isn't, again, a typical, from my experience in this case, it wasn't a typical case because there was the opening of default. There were at least 2, now 3 court hearings, and there was a lot of back and forth between my office and counsel for defendant, again, all in efforts to resolve the matter. So in total, the association, my firm spent 27.8 hours of time in this matter, and it's all itemized on the billing statement presented to the court. And with my firm, the association incurred $6,925 in legal fees, and I want to make sure $512.16 in court costs and expenses being things like the certified mailings, the court costs, the service of process by a private process server, and things of that nature. And I'm happy to subject myself to cross-examination.
Go ahead, Mr. Bastian, if you have anything.
Just Ms. Taylor, you probably said it, but did you receive a confirmation from the defendant that she had received the letter sent by your firm? Okay.
No, The August 9th, 2018 letter was sent certified mail, receipt requested, and first class mail. We did not receive the returned first class mail, which is practice in my office. If the first class mail is not returned as undeliverable as addressed or anything like that, we assume it was received. And the same goes for the second or notice of lien demand letter that we sent on October 15th, 2018. Again, that sent certified mail, return receipt requested, and first class mail. And as this hearing was progressing, I reviewed my court files to see if I had any documentation for returned first class mailing, and it was not in the file.
Okay, Attorney Taylor, one more question. The notices that you sent stated that $661.57 was owed. Is that correct? Is that was the amount in dispute at that time?
Sorry, I had someone trying to buzz in. On the letter sent on August 9th, 2018 says the amounts currently owed are assessments and other charges through August 7th, 2018 in the amount of $630.18 and legal costs in the amount of $31.39 for a total amount owed on August 9th, 2018 in the amount of $661.57.
Attorney Taylor, aside from what you just told us, the breakdown, were there any further breakdown stating where the amount stemmed for, the initial amount, the amount later, how it computed, anything of that nature?
No, but the letter specifically says on the second page, as of the date of this letter, our records reflect the above amounts as not having been paid. If you have made a recent payment towards the above amounts, we're sorry for any inconvenience and would ask that you please just disregard the letter. And then it goes on after the Fair Debt Collection Practices language to say, please direct any inquiries or comments regarding this matter to me or this firm's paralegal, Andrea Ward. Provides our phone number and our email, and we did not receive any contact from Ms. Dennis requesting a debt verification or wanting to talk about this matter to try to get it resolved when the balance was only $661.50. And I will add that that letter specifically says if the amounts due as listed below are not paid within 30 days from your receipt of this demand, all amounts authorized under the declaration and Georgia law, including interest at the rate of 7% per annum from the date of delinquency, costs of collection, and reasonable attorney's fees actually incurred, will be added to the amount currently due. So we try to put that language in the letter, one, because it's normally required by the declaration, but two, the goal here is almost always when we send these demand letters to get the homeowner to respond to us so we can work it out rather than get to the stage where a lawsuit's been pending for 2 years and we're doing a trial like this. We try to get those resolved.
In the middle of COVID. But anyway, 61 was the amount that was said. Thank you very much, Ms. Taylor.
That was on August 9th, 2018. Correct.
Okay, thank you.
Your Honor, we will tender Exhibit F, Plaintiff Exhibit F, which is the letter that Ms. Taylor was just testifying to. And we submitted that previously with the amended complaint.
Have Exhibit F. Any objection, Mr. Bastian?
No, Your Honor.
All right. Anything else for the plaintiff?
Your Honor, I would just testify now to our fees that have been incurred since we took over this matter.
Go ahead.
Okay, Your Honor, as I mentioned, we recently took over this case from Winter Capriola and Zenner. We have a total of 6 hours and 6.5 hours in this matter, $1,128 in attorney's fees. That is basically to file the amended complaint, review the documents that were sent over, the case file that was sent over from Winter Capriola and Zenner, and then compile and prepare for court and attend today's hearing. I included 1 hour of time for today's hearing in this amount. Our hourly rate is $225 per hour. This is reasonable and customary in the Atlanta area for firms that do this practice, that practice this area of the law. And it is reasonable in light of the facts and circumstances surrounding this case. In addition to that, there's been $21.55 in costs and expenses. And this was mostly the filing fees that were associated with the substitution of counsel with the e-filing system of $19.55. And then there's been a little bit of postage and copies. And I'm happy to answer any questions as well from Mr. Bastian.
No questions, Your Honor.
All right. Is that all for the plaintiff?
That is all the witnesses. Yes, Your Honor. I'm happy to do closing or give you any case law to the extent you would like any.
All right, I assume, Mr. Bastian, you're going to have some evidence and testimony?
Yeah, Your Honor.
Let's take a quick 5-minute break and then I'll hear from you and your witness.
Yeah, just Ms. Dennis. That's it, Your Honor.
All right.
Judge, may Miss Taylor be excused? I think we're probably finished with her for now.
Yeah, I have no objection, Your Honor, unless Your Honor.
There's one more question that occurred to me. So, does Ms. Kyler, does the association, when there are maintenance issues, does the association ever do self-help as authorized by the declarations?
Yes.
We do. However, with an association this size and the amount of fees that we would incur for, going to court and getting a court order, it would just not be feasible for this association because there's just so many homeowners, and this is a very common violation that occurs at Windward. I mean, it's a common violation.
So you're saying your understanding is that you would need a court order to pressure wash a driveway?
Yes, because of the fact of walking on their property. My experience, people call the police. So yes, we would need some sort of documentation that will allow us to step foot on their property to clean their driveway, because it's going to take some time.
But you never, you haven't in any of your experience ever sent any notice or given any notice to a resident, hey, if you don't perform this maintenance item, we're going to do it for you and charge you the amount.
Not in this community, we have not.
Not in that community, but in your experience in some communities, you have actually done that.
I have actually done it but with a court order, yes.
Okay. Do you have any idea how much it would cost to actually pressure wash a driveway?
It would be, the cost of the pressure washing is small, $100 or a couple $100 if that. But the fees to actually get the court order to get the work done is where the cost comes in, because my experience has been, I've actually tried to do it without a court order, and it resulted in the homeowner calling the police and shooing the contractor off their property. So, yes.
I have a question, Your Honor.
I'm slightly surprised that you have a follow-up question. Go ahead.
Believe it or not, Your Honor, I knew I was missing something with the self-help, believe it or not. And I was just telling the client, I'm like, oh, that's the one question I've had. If I may, I'm sorry, I'll be very quick.
Go ahead.
Thank you, Your Honor. Ms. Kyler, are you aware that the self-help health provision is in your document that you?
I am aware.
Provide, okay, and you are aware that it does allow you to get one without court order?
I am aware it allows us to. I'm aware of that. Mm-hmm.
Okay, and so the only portions that's not given to you are portions that are not considered common area. So is the driveway not considered common area?
Correct, it's not a common area.
So in essence, then you're not allowed to be able to impose people on clearing it then if it's not common area. Because reading this, and it seems to say that you could impose fines on common areas and things that invade the public. So if the driveway is not common area, then you can't even impose a fine on it, according to your document.
According to our document, it allows us to impose fines on homeowners that are not maintaining their property, which is Article 4 of the declaration, and it does allow us to impose fines.
On common areas. On areas that are considered common area, but not private areas. I mean,
Homeowners have a maintenance obligation to maintain their property, which is outlined in Article 4 of the Declaration. And it also allows us to, if a homeowner does not follow through, it allows us to fine that homeowner. And it also allows the association to fine the homeowner, and the board determines the fine, as we've discussed.
okay, I see that it excludes, it only says common areas, but that's my reading of it. I don't see anything that shows driveways on here.
The term maintenance it depends, it's basically their entire property. So their driveway is considered their property, and it is considered to be maintenance that they're required to follow through.
But yet you have to get a court order to get that one. All right, I'm
You
done, Your
don't
Honor.
have to get a court order, but it is more effective to get a court order.
Thank you, Your Honor.
Your Honor, if I may, just also briefly touch on this, we opened up a new can of worms here. Ms. Kyler, you mentioned earlier again that we're about at 2,500 homes on a monthly basis. What would you say is the average number of violations that are existing in this community? If you could even put a number on it or percentage on it.
Yeah, actually, at this time, when we were managing the community during this time, there was probably about 500 to 600 violations in that community because of the volume, the large size of the community. As you can imagine, there are, and it was summertime, so there was a lot of violations.
Okay, and in order to be able to utilize the self-help up front, would the association be able to afford that, so to speak, in the budget that is already established with the number of 500 to 600 violations?
No, because with the way the governing documents are, we would have to be consistent throughout the whole community. So if we utilize self-help on this person, we'd have to do it for all homeowners, and that just wouldn't, cost-wise, we wouldn't be able to do that.
Okay, that's it, Your Honor.
All right. Last chance for Ms. Kyler before we let you escape, before we think of something else.
I know. No, we're fine, Your Honor. And we want
Well,
you to
and I
take your
was
5-minute break.
I was actually asking about Ms. Taylor, if Ms. Taylor could leave.
I have nothing else from Ms. Taylor. So Ms. Taylor and Ms. Kyler, y'all can be excused, and we'll take a 5-minute break.
Thank you, Your Honor.
All right, if we can get everybody back on, we can continue.
We're here, Your Honor.
And I am here as well.
All right. You may proceed with your evidence.
Ms. Dennis, you want to raise your hand? You swear to tell the truth, the whole truth, but nothing but the truth to help you God?
I'll do.
Okay. Can you hear her, Your Honor?
So far, so good.
Okay.
Thank you.
Good afternoon, Ms. Dennis.
Good afternoon.
Okay. Are you aware of the reasons that bring us today?
Yes, I am.
Okay. And could you tell us briefly, do you reside in Wynwood presently?
Yes,
How long have you resided there?
since 2009.
Okay. And in 2009, how much were the assessment fees every year in 2009?
475.
Okay. And did you always receive a bill?
Yes,
And did you always pay your bills when they were due?
every first of,
Okay.
when it was due.
Okay. And you always waited till you received the bill?
Yes,
Okay. At some point, did the bills change from 475 to something else?
yes,
Okay. And did you pay those, did you pay those bills?
yes,
Okay. Now, at some point, did the management company change?
yes.
Okay. Tell us, in or around, is there a point that you started having some problems with billing with the management company?
Yeah, I was in my house like for probably 5 or 6 years when I started getting different kind of bills. For pine straw, for a log box, the kind you put on your house when your house is empty,
Okay.
the real estate, and an assessment fees and mowing, like the lawn wasn't mowed and things like that. And I had been in my house for 6 years.
Were these bills right? Were they for you?
No, and I kept telling them, I said, this is not mine. I don't owe you for a log box. Why would you bill me for a log box? Why would I? And I couldn't get any answer except for one person who really tried to help me.
Who was that person?
And Andrea Ward.
Okay.
She was paralegal.
So did the new billing, the billing problems that you guys started to have with them, did that start in 2016?
It started, yes, 5 years.
Okay. And is that when the new management company started coming?
Yes, that's who started, yes.
And Miss Kyler, who testified earlier, is she part of that same company?
Yes, Access Management. And that's when I started getting phone calls, a bunch of phone calls every day from Access Management telling me that I owed the bill, whatever bill they were sending me.
Okay, and the bill for the pine straw and for the lockbox and all these other things that you received that were not directed towards you, were these bills taken out eventually?
Well, yeah, because I kept paying my association fee.
Okay. But did you tell them that those bills did not belong to you and that you would have to seek legal help?
Yes, I told them that maybe they had the wrong account. Maybe they mistook me for another resident.
Okay.
But
and that's when you started having problems with the association, right?
Yes,
Okay.
that's when it was unfortunate, Your Honor. My nieces, we moved from New York, and my nieces came to visit. And we used to go to the pool house. I would just show my driver's license, and they would open the gate for us and get in. In 2017, I believe it was, when we went, they would not let us in. And I kept, and I said, why? And the guy that was at the gate kept putting something on the computer and pointing like that. And then I said, well, I want to speak to the manager. And the manager came over and he said, you can come in, this is a private club. And I left. And I tried to call them. I did write to the association, to the president. He never responded.
Okay. So subsequent to that, did you start to question every bill that they sent to you?
Well, yes, especially when I'm seeing like something like this and things like that, and yeah.
Okay, so let us take two things. First, the first one is the amount that they're alleging is that you owe $475 for 2017. Okay, did you ever receive a bill telling you that you received for $475?
No, but it was in the bill they were sending me with all the other things, $475 and $450 for the log box and $225 for pine straw. Why would I owe them pine straw? Because I have a company that does my yard every 2 weeks.
Mm-hmm.
I don't understand.
Okay.
I'm so confused, Your Honor. My head is about to explode. I'm even more confused now.
Okay. Did you keep asking them for a bill for $475 after you got a bill for $602?
Yes, I said, I want to, where is the bill for, what do I owe you? And they did send me some bills and to my email. And when I went, I looked at them and the one for the logbox wasn't in there. Then when I went to print it that night, I couldn't because all the email disappeared.
What was the reason that it says it disappeared?
I think it said deleted by sender, something like that.
Okay, and did you keep on asking for bills for the amounts that they're alleging?
Yeah, finally I said, okay, I cannot handle this. I have to get an attorney. That's when I decided. And the last thing I got was that bill for $600 and something.
Okay. Now there are two bills for $600. As we know today, there's a bill for $602. Okay. Did you ever receive that bill? Did you know what that bill meant?
No.
Okay. Now there's another bill that you got at some point for $625.
Well, that was for my association fee.
And that was the new one that had changed.
Yes.
Right? Okay. And you had received a bill that you
I could pay like $312 and $313.
Okay. And did you pay those bills?
Yes, I always pay my bills. I'm never late. I always pay my bills. Why wouldn't I pay $475? And I even asked them why. And she said, well, I'm not disputing the other bill. I'm disputing 2017.
Did you know what that meant?
No, I had no, like I said, I'm still confused about that.
Okay. But all the other bills that were specific, you kept paying those, right?
Yes, yes.
Okay. Do you have any reasons not to want to pay your association fees?
Why would I pay $625 and not pay $475?
Okay. All right, let's get to the second part of this claim. The second part of the claim is that they're saying that the driveway was not cleaned, right? Had you ever cleaned your driveway before?
Your Honor, my house was painted like 2 years before. And the first thing the guy did after he finished painting the whole house, he pressure washed my patio, my driveway, and everything.
Okay. And what year was that about?
2016. 17 or 18.
Okay. No, was that
2018.
was that before you? So was that before you got any notice of the pressure wash?
Yes, yes, it was before.
Okay. When did you come to realize? When did you come to realize that the argument here was that you had to clean your driveway?
When we came to court, you told me.
Okay. And
That's what they were disputing. Yeah.
After the first appearance, and we spoke to them.
Yes, you told me that I had to clean my driveway.
Okay.
And I said, what's wrong with it?
Okay. And so before that, you had showed me there was a letter with a different picture. Is that correct?
Yes, that's the one right here. And when I looked at it, I said, what are they talking about? This is not my house.
Okay.
It's my neighbor's house.
Okay. And after that, did you understand that they still wanted you to clean the driveway?
Well, yes, yes.
Okay.
And I did it.
Okay. After I told you.
Yes.
Okay. How much did it cost you to clean the driveway?
Less than $150. And, you know, the guy that does my yard came, right after I told him, I said, and he said, well, why don't we wait until spring? Because you're going to have, and I said, no, do it. And did it.
Now, did other homeowners also complaining about wrong bills and wrong management?
Yeah, don't tell me about what other homeowners were complaining about. That's
okay. Thank you.
No.
So right now the driveway has been repaired, right?
Yeah, there was nothing wrong with it, but I did have the pressure washed.
Okay.
And then sometimes the driveway looks like it's mildewed right after it rains, Your Honor. I have somebody that does my yard, somebody that does my house every week, but my yard every 2 weeks.
But in spite of the fact that you had somebody doing your yard, they were charging you for their people that were fixing. Is that correct?
I don't know. I really don't know what these people were trying to do. I think they were trying to, I have no clue. I don't know what they were trying to do. Try to recoup.
The last question, would you repeat that? I'm sorry, I missed it, Mr. Bastian.
I don't know what the people from Windward are trying to do.
All right. And right now,
I maintain my house and I pay my bills. Every time I get a bill, I pay.
Okay.
Except for 2017 that they are
alleging that you didn't pay.
Yeah.
But you never got a bill for that.
No.
Okay. Your witness.
Okay, thank you. Good afternoon, Ms. Dennis. How are you doing?
Good. How are you?
Fine, thank you. Okay, so you acknowledge that you have not paid $475 for 2017. Is that correct?
Yes, because I even went to my bank twice trying to figure out. I said, maybe I don't know, maybe I missed it. They look, I found all the checks from 2009 till 2021, not 2017.
Okay, okay. And you said that you moved in to your home in Windward in about 2009, correct?
Yes,
that's when December, that's when you purchased the property?
That's when I moved in.
Okay, and you own the property, right?
Yeah.
Okay. So I want to go back to this incident where you said that you tried to go to the pool or the pool house in 2017. Yes. And was that during the summertime?
Yes, it was in July.
In July.
Somewhere, it was summertime.
Okay, so you went there and you weren't able to access that, right?
Nope.
Okay, and a little bit ago, your attorney asked a question about the common areas and using the common areas, and in this finding provision in the declaration where, and I suspect this was the part, but I don't want to misstate anything. In the declaration here, it says that as part of a sanction, there can be suspension of the right to vote and the right to use the common area.
Mm-hmm.
Do you know about that provision in the declaration? Or do you understand that the association can suspend membership rights?
Yeah, but I have been to the pool before. I've taken my nieces and nephews to the pool before. I've never had that problem.
But in
Never.
2017, that was the year that you didn't pay $475, right?
I'm sorry?
But in 2017, that was the year that you didn't pay the $475, right?
Apparently so, because that's the only check I can find.
Okay, so it's possible then that that was your inability to access the pool was because your membership right was suspended?
I have no idea.
Okay, okay. So you, I believe, also mentioned in regards to the violation that you received the very first letter that was sent to you by property management in July of 2017, correct? That had the wrong picture?
I don't even remember. You know, it's been a nightmare for me since access management came on.
Okay.
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 Calling me 17 times a day. And I had to threaten them. I was telling them to back off, that I will call somebody and I would even involve the board. And that's when it stopped, when I told them that.
Okay. But as far as the driveway goes, I want to go back to that real quick. You said that you received this first letter that had the wrong picture attached, the picture of your neighbor's house.
Yes.
And that it wasn't until your attorney, Mr. Bashan, was involved that you pressure washed your driveway, right?
Mm-hmm.
And he got involved a while after it all started occurring. So in January of 2020, is that when you finally corrected it or pressure washed your driveway?
Yeah, I pressure washed it right after he told me. And then before, my dad would get pressure washed every time I paint my house.
Okay. 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 I think that's all for this witness, Your Honor.
All right. Any follow-up, Mr. Bastian?
No, Your Honor.
All right, I have a few questions for you, Ms. Dennis.
Yes.
So we talked about, and you've been asked about the notice that you got from Access Management with the wrong driveway.
Yes.
All right. Did you get any other notices from them after that one about the driveway?
No.
So that was so you're saying that's the only one you received?
Yes, that's the only one I have.
Did you ever get a notice saying that they've referenced here today that said you were going to be fined $50 a day?
No. Mm-mm. Nope.
All right. So you mentioned that, whenever you got a bill for your assessments, that you would pay that bill, right?
Yeah, a statement like this, yes.
Okay. So any of those statements, and you have a statement like that there, any of those statements that you have reflect, have on them the fines, the total fines owed?
No.
For the property?
No, Your Honor.
Now, talk to me a little bit about what communication you had with Access Management Group about the driveway back in 2018, after you got this notice? Tell me what communications you had with them about the driveway.
I believe I called once about that and tried to talk to Melissa. I don't even remember her last name. And she told me, no, I don't talk to me. You talk to our lawyers. That was the only time I spoke to her.
And when was this? Was this in 2018, shortly after you got that notice, or sometime later?
I think it was shortly after I got that. And Your Honor, I'm so sorry because it's very hard for me. It's been so confusing. So I'm trying to remember exactly, but yeah, I never spoke to anybody else after that. What's his name? The one that she mentioned, that the property manager, none of them.
All right. I think that's all I have.
Thank you, Your Honor.
Your Honor, may I ask one follow-up to that?
Sure.
Ms. Dennis, you mentioned on the statement that you received, is that statement, the ones that you have there, are those that year's notice of annual assessments, like a coupon booklet, or what is it?
Just as association fees. Statement for association fees.
It's dated 2/1/2018, and it's for the 6/25.
So it's like a coupon for that particular year's?
I don't know, it says statement, so I don't know what's a good one. It's a statement for that year.
Okay.
For
6/25.
For 2018.
Yes,
Okay.
exactly.
So it's kind of listing out that year's annual assessment?
Yeah, so 6/25, and it was paid after.
Okay. And then one more, Ms. Dennis. So earlier, Ms. Kyler testified that she had sent, her office had sent a total of 6 letters. I believe there was 4 violation letters, 2 late letters, and then the prior law firm sent 2 letters. And you're saying of those 8, you only received 1 letter, which was the violation letter with the wrong picture?
Yes, that one right here.
Okay. That's all I have, Your Honor.
All right. Anything else for you, Ms. Bastian?
No, Your Honor. We just do closing arguments for me.
I think Ms. Sierra gets to have the last word, so
Okay.
hear from you first, Ms. Bastian.
Okay. Well, Your Honor, in our part, even we as attorneys finally got a hold of what was demanded until this case came. Through all the discovery with the prior firm and with this firm, Your Honor, we've been trying to zero in onto what was owed because the client kept asking, what is this? We finally figured out, truthfully, with Miss Sierra's firm, that is $475 is the crux of this case, because she kept asking, what do I owe? Because none of the amounts, they match up to what she usually pays before. There was no $475, there was no $625. And she kept asking, as she testified, send me a bill, do me something so that I could know what to pay. She just didn't know that she was coming this $475. I will concede, Your Honor, right now, as the evidence look, that probably she owes the $475, but to have penalties because of the $475 and because of the wrong billing or because of the reason why, I don't think that's just. The other thing is, she testified that when Access Management group came in, she started having other problems with them. So they were billing her for landscaping fees for other people when she had her own landscaper. They were charging her for lockbox and things of that nature. She didn't have any of these things. So she became suspicious of every bill that she's gonna get, that she gets. And it's within her right to know exactly how much she owes and to get a bill from them because they don't send her the right bill. Second part, let's hit the driveway. Now the driveway, they sent her the letter with the wrong house. Okay, she still is weary of them, of what she has to do and not do. And granted, 2 years prior, or a year and a half prior, she painted her entire house and pressure washed the driveway. So she cannot fathom why in the world is this thing so bad, or do they want that? So finally, she kept thinking, what is this? It's not until we had our first appearance in court and we had a conference and then they started actually redacting a couple of things, because right now it was evident that a lot of the bills that they were sending were not actual bills. Then it came to write pressure washing for the driveway. I told her, listen, go pressure wash your driveway, because that seems to be the crux of the thing. That's the reason why it took her so long or that time to do it, because it's not that she actually understood that, listen, we need to pressure wash. I just sent the proper bill before, the proper house before something in the beginning. She could have probably done it. So she has rectified that. So I think the last thing is that their agreement says reasonableness. It's got to be reasonable attorney's fees. We can't be paying for fees for attorney's fees that they racked up because they were not specific enough, and because because the court schedule, not anybody else has put us in a certain way. I mean, it's not anybody's fault. It's not her fault. And you're talking $475 in a driveway, and now you're talking about almost $30,000 that she has to pay. I mean, in the sense of reasonableness, that's just not right. I mean, no wonder why we can't get this on this case. Is because the numbers, it's fathomable for somebody to want to pay that much when she has tried to do things over and over. Ms. Dennis, you want to say something?
Yeah, and it was the only time, 2017, that I did not get the statement.
Yes, I think the judge understands that by now. That's the whole thing. She pays her bills. She pays her bills regularly for anything. She's one of those people that she cares about what people think about her, and she's responsible. So I don't think that attorney's fees should be awarded on this thing. I really don't see. And when we question them about how the assessment fees get done, their agreement says $300 for some special assessment. How do we know which assessment for another? And then now you can't even tell which fees and how they compute it. It seems as if they want to decide $10,000. That's fine, as long as the board does it. I think somebody has got to review their agreement and put some specificities in it. That's what I have, Your Honor. Thank you for listening to us, and thank you for your time.
Thank you, Your Honor.
All right, Ms. Sierra, you get the last word.
Thank you, Your Honor. So here, the situation is Ms. Dennis owns the property at issue in Windward community. Therefore, she is bound by the governing documents. The governing documents have certain obligations of owners. To pay annual assessments is one of them. She's admitted she didn't pay the 2017 assessment. There's actually no obligation of the association to send each individual owner a notification aside from the annual budget. However, the associations all do. I'm not going to say that one wouldn't get lost in the mail. I have no idea, but for Ms. Dennis to not receive 8 letters or 7 letters, whatever it was we said, she was notified of all of these issues multiple times, even by this management company that took over mid-year of the assessment. No, they didn't send one showing 475. They sent a late letter too, with the balance as of that date that was owing. They didn't receive the payment. That's not in dispute here. And then there's the issue of the violation. They notified her multiple times over the course of 5 months before imposing any fines. And then fines went on for a year before the violation was finally corrected. So while I understand that Ms. Dennis thinks that $18,000 is maybe unreasonable for a driveway violation, I contend it is unreasonable to maintain a driveway violation for 17 months. And that's how long it took. As far as the attorney's fees go, Ms. Dennis did not respond to any of the communications that she received from management or the prior law firm. So the fees, as were testified to, the attorney's fees, they were reasonable. They were necessary to get to the point. Unfortunately, we can't just appear at trial without going through certain steps in these cases. We have to do title searches. We have to do bankruptcy searches. In this case, I understand that Mr. Bastian was involved a little bit later on after the suit was filed, but significant amount of time had already gone and work had been done. And those hourly rates and fees are reasonable, and everybody testified to those. And then the fees that were billed by my firm, over $1,000, was to get to the point of here having the bench trial today, Your Honor. Not only does the governing documents allow for the recovery of the reasonable fees incurred, attorney's fees incurred by the association in their efforts to collect and enforce the covenant, but OCGA 44560 also supports that. Reasonable attorney's fees actually incurred is the actually incurred to the extent it's provided in the documents, which here it is. Also, Your Honor, the case law completely supports this as well. There's a number of cases on point. The one that comes to mind, We Hunt v. Wren's Crossing Condo Association. While it's a condominium, it is a similarly situated association. And yes, they have the Condo Act there. Here we have the 44560, which basically is the same language there. But in that case, there was $900 in principal owed at the end. There was over $9,000 in attorney's fees in that case. And the court ended up awarding those as the reasonable fees to get to that point. The principal amount or the very root cause of why we're here doesn't necessitate what is reasonable or not. The fact is we're here because there was an issue. And in fact, this case, there was two issues, the 2017 assessments and then the fines imposed for the violation of the driveway maintenance issue. Also, Forest Villas Condominium Association, again, a condo association versus Camaro, it is, again, similarly situated. It's an association of a group of homeowners. There's no valid reason for failing to pay assessments. The 2017, whether or not she received the one coupon book, she would have been receiving the annual meeting notice, the late letters. There was multiple things mailed that she did not respond to or pay. Therefore, the association is entitled to recover all of the amounts sought. The principal with the 475 and the fines totals $18,845. The interest at 7% that Ms. Kyler testified to of $136.26 at the 7% amount allowed by case law and the Georgia statutes. The attorney's fees all added together, winners and hours, $8,015, and all of the court costs and expenses of $533.71. That's all I have, Your Honor.
All right. It's amazing to me that we got to $20,000 over one unpaid assessment and pressure washing a driveway. It's an enormous sum and seems to me greatly disproportionate to the offense. But I think if there had been evidence fully documented of proper authority, continuing notice, and continuing efforts to get this resolved, that I could justify. But that's not what we have here. As far as the assessment goes, she owes it. She didn't pay it. She can't show that she paid it. So whether there was a notice or not, she has to pay it. And regardless of what concern she had about other things that were incorrect about the bill, she knows or should know that she needed to pay that assessment and it wasn't paid. So assessment, so the 475 assessment, a late fee, and interest on the unpaid balance, I think that's due and owing. And some reasonable amount of attorney's fees for having to collect that, I think is due. The fine's another issue. The first notice of the fine was incorrect, that had the incorrect house. The second notice had no picture on it. She had a reasonable grounds to dispute at that time that those notices were correct. I have a hard time believing that she didn't receive any of those subsequent notices. I think she did get the subsequent notices. I think she did get the notice from the attorney. And I think as she testified is that there were just so many problems and there were things that were off and not accurate, and she wasn't getting a response satisfactory to her when she called, that she just put it aside or thought that it would be either written off or corrected somewhere down the line. The property manager said, well, we sent out these notices that would have shown all the fines accruing. There's no evidence of that. If there was these constant notices going out and she paid and it was on the notice and she paid the assessment, then she's got some constructive notice there, but I don't see that document. I also don't see any documentation showing the authority for the fine in the first place. Yeah, there can be a fine, but there's got to be some reasonable notice to the property owner. And there's no evidence here in the record of the bylaws or the rules of the association that say, what's the process? What's the amount? And this seems to me to be a failure of process. That certainly there is a scenario where you could recover all those fines, but there's just not enough supporting evidence here to justify the assessment of those fines. So I'm not going to order judgment for those unpaid fines. It's been corrected, and I don't believe there was a proper basis to impose them in the first place, at least not through the evidence presented to me, and certainly not any continuing notice, any evidence of any continuing notice thereafter. So I'm not ordering any payment of the fines. It's going to be $475 in the assessments plus interest, and I'm going to and I think there was some lack of response. I'm going to order $1,000 in attorney's fees.
And any of the court costs or anything, Your Honor?
Court costs, I'll award the court costs. The lawsuit itself was justified. I think you weren't ever going to collect anything if you didn't file, I don't believe. So you're entitled to that, yes.
Okay. Would Your Honor like for me to prepare an order and circulate that?
Yes, please.
Okay, I will do that and we will get that circulated around.
All right. And anything else, Mr. Bastian? You're on mute.
Yeah, just so we could understand, Your Honor, at least for Ms. Dennis to understand very well. It's nice when it's coming from the court there. So you're definitely awarding the $475 and you're awarding $1,000 in attorney's fees.
That's correct.
And then plus interest? Or that's it's $1,475?
the interest on the 475 assessment, not interest on the attorney's fees.
Yeah, the
Okay.
interest that was testified to was only on the assessment of $136.26.
I'm going to award that interest, yes.
So we're talking about $1,600 about.
That's correct.
And then
Okay.
the court cost, which we will add in there.
That should be $200 or $300, somewhere in that neighborhood.
Okay, thank you, Your Honor. Thank you for your time.
Thank you.
Thank you.
Thank you. May we be
Welcome.
excused?
Appreciate you and everybody's patience.
Thank
Okay.
you.
This